is really a wonderful topic which deals with the two major enactments. And bankruptcy code and other one is Companies Act 2013. I think there are about 20 participants are there. So my deliberation is going to be the Interplay Act, both Companies Act as well as the Bankruptcy Code. In fact, nearly 7 years or okay, still we have to explore and try to understand. We are in that position. What is the interplay between how the act provides for each other and enables each other to function. Now, today's session is that to attempt is just an attempt to understand okay what exactly the code provides for. And as you all know that Companies Act 2013 is much before the companies. Of course, it replaced 60 years old law of 1956 Act, and the Companies Act 2013 has enacted and came into force. Then after that, as you all know, Insolvency Bankruptcy Code 2016 also came into effect much after Companies Act 2013. But still, the question comes here. After advent of Insolvency Bankruptcy Code, whether the Companies Act provides a proper reference or enabling provisions or a proper corresponding provisions which enable practice of or implementation of Insolvency Bankruptcy Code 2016, that we need to analyze and understand. In fact, today I have a few PPTs for you, and I prepared for Companies Act and IBC. In IBC, I've got 2-3 PPTs which I wanted to share to you all. After a session over, I may share all that. But before that, my idea is to not to just share the PPT, or run through the PPTs and explain all that, because we all know that now most of us would have bit understood the law better, okay, than the time when the law came into force, because we almost passed 6-7 years almost after the enactment of IBC code and 10 years after enactment of 2013 Act. So now the exercise today should be for us to understand what are the enabling provisions and what we need more further in the by way of an amendment or by way of an notification clarification to see that this code and Companies Act both travel together and in parallel. Okay. Now, before proceeding further with my PPT, because I told you I got more than 300 slides of my Companies Act and some 70-80 slides of IBC code. And IBC code, I got different topic, got separate slides for each topics. So my idea is not to simply run through and explain. Before that, I want to exactly understand from the participants so that I will be knowing my line of discussion, okay, and I'll be sure on what side I concentrate. If I really get your inputs also on that, rather I'm going monotonously from my side without understanding what is the participants' expectation, and of course, it's all about deliberations. It's not that something I'm going to innovate and tell you. It is there in the law, and we all we are all witnessing, and also we should say we would have victimized also. Okay, both would have been there in our cases which we are handling. So there is nothing for me to teach and for you to learn. Let's have kind of a deliberation. I'll also explain you by sharing my PPTs, and before that, I wanted to understand whether the Companies Act has really got amended or has got provisions in tandem with the provisions of Insolvency Code. Is it, or is that provisions what is already in effect? Is it sufficient? Is it enough? Or do we need furthermore amendments or enabling provisions? Any of the participants? Any inputs from participants? You can share anything. You can feel it. It's an open forum where we can share, share our views, so that at least not today, tomorrow and future, maybe given effect by authorities, what we are discussing today. Any inputs from participants? Whether the existing IBC or existing provision connecting Companies Act in IBC, is it sufficient or much more we need? Or particularly in which area we need it? Any particular area that you feel that it's very important, where there's a complete gap between IBC and Companies Act? Can you just tell me a few things on where we can focus on bigger gaps, leave smaller gaps? Any idea, participants? You must be practicing all, right? Must be practicing insolvency professionals and other advocates and CS and CAs. So you must have encountered some of the issues, and still you may feel that it is much more required. Or if you leave me, I'll quickly run my PPT and I will finish my session. There won't be a scope for this deliberation at all then, unless you deliberate and discuss. Any inputs from you? No, you have nothing to share. First of all, you are all there or not?
Yes, sir, we are here.
Yeah, please. No, at least you should give some kind of a gesture to feel that, yeah, I'm in between the professional group. Okay.
Sir, good morning.
Morning.
This is Velli Parameshwaram from Chennai.
Please.
Sir, we are appreciating your presence, and as you are expert, we'll learn more from you in these hours.
Yeah, fine. I'm going to really share my both experience, whatever I have in my limited knowledge. With your experience, I was asking that, is it sufficient or we need much more? Because if you
The
don't,
Companies Act may more amendments synchronized with IBC laws is required of the awards. But one aspect, the adjudicating authorities, NCLT, they are mostly depending on IBC and not on Companies Act. Right. When our IBC comes, the NCLT mostly refer the IBC Act. They are not referring any Companies Act, or in their order, they never mention any of the Companies Act section in their judgment related to IBC, sir. So amendment may help us to practice more, but the adjudicating authority is mostly depending on IBC only, sir. That's my view, sir. Thank you.
Say any other views? I see from Mr. The more of focus and more of deliberation is taking place in courts, only in IBC, without much touching upon provisions of Companies Act. Without much touching upon, even though it may be required to. Okay, so that's what he felt that more focus should also be given to Companies Act also, and in addition to Insolvency Bankruptcy Code. Any other views on this? Okay.
Sir, one question.
Yeah, please.
The entire concept under Companies Act is collective wisdom of the board of directors.
Correct.
When a company is admitted under CIRP,
Correct.
the board of director gets suspended and the IP is appointed.
Yes.
Are we compromising on the collective wisdom concept?
So the collective wisdom didn't work. That's why, and it has come to the hands of court. If collective wisdom would have done things properly, then it would not, the CD will not step into the, steps of court. So actually, till collective wisdom works properly, nobody interferes with the affairs of the company.
But when the things are not done properly, it should be all the more necessary that you need collective wisdom
Correct.
principle to be strengthened more, because there is lack in that area also, that the those who were running the affairs of the company have not acted diligently or have not performed their duties diligently,
Okay.
and therefore you are appointing an independent professional. But in such a case, whether IBC should consider having two IPs in whatever manner, or so that collective wisdom is there, the responsibility on the shoulder of only one insolvency professional.
No, see, you mean to say, just to clarify myself, that in every case you suggest if two IPs appointed, that would be better?
Maybe one as the like a chairman and managing director, like one's main IP and one another professional, so that there is collective wisdom. There is no one person is held responsible for the entire thing. Compliances, running the affairs on the as per the when the company is a going concern, everything is run by one insolvency professional.
Can I say something? Can I say something? I think see,
Yeah,
board of directors takes responsibility, and it is assumed that the company will have perpetual existence in
Okay,
the same form with the same ownership.
correct.
Whereas when you have RP, IRP or liquidator, you know that the company is going to be handed over to a different management, or the company is going to be liquidated. So the RP has a limited purpose of following and conveying, following a particular process of law in order to hand over the company probably in different hands. I'm not saying better hands, but in different hands.
Okay.
So basically, the objective is completely different, and RP basically has to follow the process of IBC and the regulations and all that. So I don't think a collective wisdom is really warranted in this case.
My experience, I'm not very well experienced, but my experience that still the creditors come with the recovery mechanism in their mind. The financial creditors, they still have the recovery as the prime thing in their mind and not the resolution in their mind.
Because
from
now,
that angle,
because now the IBC has been brought in by the government in superior to SARFAESI. That's why they are bringing that SARFAESI expectation in the IBC. What you are telling, no? I'm just supplementing. Okay. That SARFAESI expectation, whatever there before earlier with the banker, the same expectation now the banker is bringing in the IBC because of the the power, superior power given to the IBC than the SARFAESI. That means the attitude of the bankers are continuing. That's what you are referring, correct? I'm just supplementing to that.
okay. Thank you, sir.
So yes, any other views? Yeah, so good point that's being raised. But here we are talking about the issues of the practice or issues of the way the code is getting implemented. But today, of course, that's very important to discuss. In fact, we had a number of discussion also, deliberation also. ICCI has done. I myself addressed few sessions. We discussed a lot of issues in that. Now, today's issue is that any changes is required, amendment is required in Companies Act or code with respect to Companies Act or in Companies Act with respect to the code, is anything is required to make sure things are working properly. That's what the today's task given to us to understand and give our inputs or probably go with a better understanding. So is there any other inputs on that? Or I can move on. Of course, though the problems or issues are shared here, those are very important. The point which our friend has shared, the two RP whether can be appointed. I don't think that way things will work, because giving responsibility one person only will work. Otherwise, the each will blame the other one. Possibilities are there. The next one is that see, that's the reason there's an examination, there is the training, everything is given, and of course, the days have gone where when the IBC code has come, many of us may not know what to do. Correct? You all agree? After taking over the CD. In the beginning, I'm saying, when the code has got introduced. So at least now we know, at least, after 6-7 years, little we are. Do you agree or not? Whoever took company corporate data will be endorsing my views, right? Because there was no provision, there was no have come, so many clarifications have come. At least we are in a little better position, but still the problem of RP liquidator are taken care of. That's a $1 million question that we have to wait and see, and we have to share our issues. Then only the ministry will ministry or authorities will understand, and they will try to help us. Okay. So I don't think this appointed 2RP may that level work, but the one point is good where one person becomes responsible for the entire show, where when it is a company, the collective wisdom and many people are sharing the responsibility. Here, what I would suggest before starting my session, leave at all appointing 2RP in one assignment. At least let everybody cooperate to the RP. That itself is a great help. Will you agree or not? COC, department, etc. Let them first cooperate to the RP who is appointed in the CD. Let them understand. Sorry, yeah, please.
I fully agree with your view that there has to be a cooperation from everybody. My understanding is there are timelines prescribed for everybody except the suspended board of directors.
Yes.
If the cart and the bulls have to move towards a particular achievement of a goal, then suspended director should also be held responsible within a time frame that they have to provide information. They simply take a stand that under section 19 you file an application. Once the court directs, we will take. Now section 19 applications are pending for more than 6 months, 8 months by the time CIRP is also getting over.
Yeah, you're right.
There should be time frame for suspended board members also, that they have to act within a time frame and provide information to RP.
Yeah, correct. You are right. There is no other doubt. That's what I was telling. More than appointing 2 RP, if everyone understand their responsibility, that one man who is no way connected, okay, and still just because of the the direction of the court is following the rules and regulation and trying to dissolve the company and trying to do best whatever possible way. Okay, if that people understand, that itself is a great help. And here, right from corporation to income tax department, they don't want to understand the IBC and they don't want to understand RP liquidator. They wanted to follow their standard. Just like a running company, how they have to do without the law provides for. In fact, many of the provisions may not be applicable for companies which are in CIRP or, of course, more specifically companies in liquidation. But still, every department is insisting to follow. And even every stakeholders or everybody around us wanted to RP and liquidator to perform. Even though practically it is impossible, theoretically only it is possible, still they wanted RP and liquidator to perform to their whims and fancy. That is more important. If they want us to perform as per the law, then it's okay. But they wanted to perform as to their whims and fancy, failing which they usually raise the grievances against the RP and liquidator. Hope you agree all. Okay, let's go into the topic. Is any other views, or I can close and move to the my own presentations? Okay, now with the basic prelude, what we also liquidator of companies, so practicing CS. So I also face difficulty as if I'm not, I'm comfortable. It's not like that, but the task is given to me to analyze the provision and brief you all, or probably to share my views with you all and also take your inputs. So I am before you now. Otherwise, I am one among you. Very simple. Okay, put it very simple. So let's all try to find out the way. I'll share my screen. Okay. See what is my today's plan of action is that Companies Act vis-a-vis insolvency bankruptcy code. It's a big topic. I think in every provision I can say the difficulties, right? In every provision I can say the difficulties. We will try to within given time we'll try to understand, okay, and possible whatever possible today for today's discussion, today's topic. We'll try to deliberate and consolidate our views and share it to institution. Let them take it forward. Then let's see what's. But let's do our duty, whatever provided for in the law. So, if you see Companies Act and the Insolvency Bankruptcy Code, okay. Now, in my personal view, if you see, there are much more amendment is required under Companies Act. Okay, that's what I was asking you this particular question to you, but probably I don't know, you don't want to utter it openly, or I don't know what. You are not ready to share it, but as a speaker, it's my duty. I can't keep myself everything in and talk something else. So I have to talk openly. So we need much more amendment in Companies Act. There is no doubt. In fact, whether I would say the code is very nicely drafted one and even getting implemented nicely, subject to certain exceptions, which few people always misuse any law in our country. Same way, few people are misusing the law. It happened in code also, but that should not happen because of the absence of provision in the law. So the government should not allow the wrongdoers to make use of law for their benefit just because of the absence of law in the another act, or enabling implementing some particular thing against them. Okay. Now coming to the Companies Act 2013, I have 2-3 segments to discuss with you. You can share your discuss. We will deliberate, then we'll move forward. As I was telling from the beginning, it is not the class. We are all practicing professional. We are all sailing the same boat. If you are facing issue, same issue I will also be facing. If I am facing it, you may also be facing the same. So I am not discounting myself, okay, from anything. Now coming to the Companies Act, I want you to take you to before going to my PPT. I have a PPT about Companies Act PPT. I'll just share you that PPT. You are able to view my PPT? You are able to view? You are
Yes,
able
sir.
to view my
Yes,
PPT?
Yes, sir. Yes, sir.
See, this is a PPT on Companies Act. See, wanted to show this. This I got, I think. Let me, yeah, the last page. If you see, the slide is coming 342. Okay, my slide is coming 342. If I take only what is there in the Companies Act itself, my 3 hours will go away. Okay, my duty is not to do that. I'm not here to do that because such a vast subject is the Companies Act. Okay, where I could prepare a PPT for to bring reference to another enactment of two. That means I have to say that 470 section without section of IBC. Okay, reserves to 255 sections of IBC. Okay, so now why particularly I wanted to bring this first Companies Act. I want to because our focus more going to be in the IBC code. Okay. Before touching the IBC code, let's go into the important aspects of the Companies Act. Let's try to understand what are the important aspects of the Companies Act. Then we will see what is provided for, what is not provided for. Okay. Then we could able to compare and we can try to understand whether is it sufficient or something else should be done by the authorities and government to see that both Companies Act and IBC goes in tandem. Travel in tandem. Okay? So I'll do one thing. Before going into my 300 pages of slide, I will take you through Companies Act. Okay. Because I just wanted to see I should take this opportunity to share whatever I feel or whatever I learn or whatever experience I want to. Prefer to take your views. Why? Because tomorrow I may face similar issues in my own assignments. That's why I always seek views of, and also to share our views, the consolidated views to the department to me. At least it is taken care of. Okay. Now, Companies Act 2013 ballot is before you. See, where are the reference of the insolvency code is coming here. Okay, let's try to understand how the Companies Act and insolvency code is gelling each other, or authorities want to gel each other, are giving some effort, but I don't think they're given much effort, but they try to give some effort. Let's see what are those. I'll just put a insolvency and find out. I already seen it. For your purpose, I'm just putting. Okay. So now, if you see in the definition part, okay, they amended. I mean, in the memorandum, right? Okay. This is second one. The first one I showed. Yeah. See, coming to this, they have included by way of amendment where winding up means winding up under Companies Act or liquidation under the. Okay. First, let me push this question. Okay. That means winding up is different from liquidation, or whether the winding up and liquidation is one and the same. If you have anybody, if you have any views, you can share me. Can you share me whether the winding up, liquidation and closure or strike off all are one and the same? Of course, closure and strike off, we all know that it's totally different. But at least let's try to understand. Winding up and liquidation, is it the same or different? It has got a different meaning, because now by way of amendment, a liquidation word is included. That means this is going to say that winding up earlier, before advent of the insolvency bankruptcy code, winding up does not provide for liquidation. Any views? What is there any much difference between the winding up and liquidation? Or both are one and the same? Both are one and the same. Or is there any differences there in both? Okay. views, the department confirms that amendment that winding up earlier, which was including only covering only winding up under the Companies Act, now also includes liquidation under IBC. That means tomorrow nobody should take an argument saying that this winding up, that means the liquidation under the Insolvency Bankruptcy Code is not a winding up under Companies Act. Nobody should take that argument. Therefore, because the winding up word comes in the Companies Act 2013 in so many places, hundreds of places. So that's why they, for the, what to say, for safer reason, they brought liquidation within the meaning of the winding up. Okay. Coming to the next one. I'll quick. Now the next amendment again. This amendment has come in. I'll show you here. Because otherwise you may have been 8 company we call, right? In that the amendment has come whereby in case the company is just like a when the is wound up, the law provides for that we transfer to another similar trust having a similar. Okay, same the in case of closure of business or in case of closure of operations, on a winding up a dissolution of, if there remains after the payment of all debts and liabilities, the same has to be transferred to another company which is registered as Section 8 with similar object. Okay. Suppose if that's not the case, it's not happening, then it has to be sold. The process has to be credited to the insolvency fund. So now the insolvency bankruptcy fund has been formed under Section 224 of the IBC code. Okay. So now the companies which is formed under Section 8, when the affairs of the Section 8 companies get closed or wound up, what are the left out assets if sold, the process has to be credited to the insolvency bankruptcy code. So they given a link because they don't want to form a separate fund or authorities for this purpose. So they made it by an amendment they brought this particular provision and ensuring that whatever the fund left out on the Section 8 company should be transferred to the insolvency fund. Okay, then where else? What else? Then again coming to this reduction of share capital. Okay, in what it says reduction of, most of you must be knowing reduction of share capital. You all must be knowing that share capital and reserves can be reduced by making an application petition to the NCLT. Earlier it was originally it was before the High Court. Now after advent of after the introduction of the NCLT, then now reduction of share capital by way of petition has to be filed before NCLT under Section 66. What the provision provide for companies that, see, after doing a reduction of capital, what it provides, there's an amendment brought in after the Insolvency Bankruptcy Code where it says where the name of the creditor, okay, it's very important to see, where the name of any creditor entitled to object the reduction of share capital under the section is by reason of his ignorance of the proceeding. That means if he is not aware of the proceeding for reduction or the nature or effect with respect to his debt or claim are not entered on the list of creditor. And after such reduction of capital, that means after reducing the capital, okay, if the company commits the default within the meaning of Insolvency Bankruptcy Code, so that means after reduction of capital, okay, if the person, the creditor, okay, where the name of creditor who is entitled to object the reduction of capital and whose name not entered in the list of creditor, okay, what he can do? So when there's a default after doing such a reduction, when the company commits a default after doing reduction default, and within the meaning of section 6 of the Insolvency Bankruptcy Code in respect of the amount of his debt, then every person who was a member, see, this is the consequences. Okay, shall be liable to contribute to the payment of that debt. So this is very important provision, because it should not happen. It's a backdoor entry where the members are taking away the capital after keeping the creditors debt unpaid. Okay, so just it should not be a backdoor exit for the shareholder. That's why the government authority felt that after doing the reduction of capital, if there's a default of that particular debt of the creditor, then they have to make sure that the member of the company, after the date of the registration or order of the reduction, they are liable to contribute to the payment of debt directly. Okay. So if the company is wound up, then tribunal not making an application by creditor and they settle the list of creditors so liable to contribute and enforce the whole thing. So this is the amendment has been brought in to bring remedy or relief to the creditor who was not excised under the Companies Act 2013. Okay. Now, no, I have not gone into the issues at all. I am just what are today the cross reference between the Companies Act and Insolvency Code. After finishing this, I will come to the real issues and what are the real changes that we may require, or what is already there, how it is getting enforced. All that we will discuss little later after I will take you through, so that we will have a clarity that we have seen whatever the corresponding changes that had been brought in by Insolvency Code in the Companies Act. That once we see it, we will be clear. Then we can discuss and deliberate what more required under the Companies Act 2013. Very few amendments only, changes only is done. I'll another 10-15 minutes, I'll close this. Okay. Now, again, the next changes is that in section 77, okay, see the headings of that. So duty, okay, in that the clear changes have been, amendment has been introduced, whereby notwithstanding any God, there's a non-obstructive class. Okay. No charge created by a company shall be taken into account by the liquidator. That earlier we used to only see the liquidator appointed under the Companies Act 2013. Now, the case for the liquidator who is appointed under the Insolvency Bankruptcy Code is section issues of the liquidator under the Companies Act. Same privilege or same responsibility duties, whatever casted upon to the liquidator under the Companies Act 2013, now extended to the liquidator of the Insolvency Bankruptcy Code. Okay. Now, because of that, what is the impact of it? Now, it starts with a non-obstructive clause where notwithstanding anything containing any other law for time being forced. Very few sections in the Companies Act has got this non-obstructive clause. Okay. In 77.3 we have got it, but it making it clear that no charge created by the company shall be taken to by liquidator unless it is duly registered under subsection 1 and certificate of registration of charge is given. So what subsection 1 says? It is duty of every company creating a charge within or outside this property undertaking. So charge on the property, assets, or its undertaking, whether tangible or otherwise. Okay. Now to register the particulars of charge signed by the company and charge holder together with the instrument creating a charge within 30 days of its creation. That we all know that we create a charge under Companies Act. Now, the same duty or responsibility and protection is mandate, I can say even mandate, is extended to the under the provisions of Insolvency Code for the corporate data which is coming under the provisions of Insolvency Code. Now, if the CD which is under the either CRP of Insolvency Bankruptcy Code 2016. Now the duty of the RP or liquidator is to see whether the charge is registered or not, to deem a creditor as a secured creditor or not. I think you would have seen now there are a lot of hues and cries are going on. So many cases are going on in the court whereby the home buyers, they wanted to claim themselves as a secured creditor, and government in few, of course, the Honorable Supreme Court has given in few cases where the government dues are secured creditor, but by subsequent judgment, the same Honorable Supreme Court has said that that views and that interpretation could be applicable to that particular case because of specific provision in that particular enactment. So, there was so many interpretation where whom to be brought under the purview of secured creditor under the Insolvency Bankruptcy Code. But here, under the Provision of Companies Act, Section 77(3) makes it very clear that no charge created by a company shall be taken into account by the liquidator unless it is registered under subsection 1 of the Companies Act under Section 77. That means this makes it very clear that the liquidator cannot deem any charge or any security or any creditor as a secured one unless charge is registered under Section 77(3) of Companies Act. Hope you are all with me. Now, this answers many of the interpretation which is going around, actually speaking. Of course, there are different interpretation can be drawn out of it, but still, the law makes it very straight and clear that a liquidator should act upon only with a registered charge under the Provision of Companies Act. This only we need to understand here. Okay. Now, coming to next provision. The next provision is on resolution agreements to be filed. We all know that Section 117 provides for certain resolution and certain agreements which need to be filed with the Registrar of Companies. We all know that earlier there were Section 173 was there under 1956 Act. Now the equivalent is 117. Yeah, okay. In 2013 Act, where it says certain resolution needs to be registered. Okay. Now, by way of an amendment, resolution requiring a company to be wound up voluntarily passed in particular Section 59. This also need to be registered under Section 117. This is more important to understand. So that means the consequences of it not registered, the consequences of Section 117 will follow. Because Section 117 of Companies Act 2013 mandate certain resolution has to be compulsorily be filed. Okay. So this provision of this section shall apply to special resolution and resolution were agreed by all the members. Any resolution of the board of directors executed by company for appointment, de-appointment, renewal of MD, or any resolution, same thing that which is accepted by agreed to by class of members, then resolution requiring company to be owned up voluntarily. That means every person who has been appointed as a liquidator under Section 59 by the company by means of resolution should make sure he is filing the resolution. So this makes very clear what is the responsibility of the liquidator who is getting appointed in the voluntary liquidation under Section 59. Okay. So next, action to be taken in pursuant to inspector's report. Okay. So now, if to understand the nuances of the Companies Act vis-a-vis the insolvency or with respect to the provision of insolvency code, if from an inspection's report it appears for CG that any person in relation to company, body, corporate whose effort has been investigated in the chapter been guilty of any offense which is criminally liable, Section 447, if he is criminally liable, Section 447 of the Companies Act triggered. Okay. the CG may prosecute such person for the offence. Duty of the officer employed to give settlement as an assistant in this regard. Okay. Now, this connection, if any company body capital liable to be wound up under the Companies Act was provided earlier. Now, it is not only the company liable to be wound up under Companies Act, it is also the company or body capital liable to be wound up under Insolvency Bankruptcy Code also. It appears to the central government from any such report made under 223 that it is expedient to do so by reason such as of 2013, section 30, 213. Central government may, unless the company is already being wound up by tribunal, cause to be presented to the tribunal by any person authorized by central government to make a petition for winding up company on the ground that it is just unequitable that it should be wound up or by an application under section 241. Okay. Now, from this, what we could understand, that means whether earlier it only section provides for the inspection report means section 224, but earlier provides for only company which is liable to be wound up under Position of Companies Act. Now, the same section provides for not only the companies liable to be wound up under Companies Act, also under Insolvency Code. And if the company is liable to be wound up under Insolvency Code, if the government after inspection, out of the inspection report, they are able to make out a reason that the company's operation was not, means the affairs of the company has been found guilty, okay, then they should make an application. They mean they may authorize central government. It should not be wound up by, and it is just an equitable, because if it is IBC, what we do for 330 days, we do CARP for recovery, for revival, or for recovery, okay, for revival. So we take 330 days under CARP. During that period also, if the central government feel that the operations have been conducted in such a way that criminally liable, it is a duty of the central government to file make a petition. Okay. Now coming to next one. This is very important, very important. This is very important. Why I am saying this? I have a separate PPT for this. Okay. This is a PPT. Just that one line change the entire episode of the IBC code. That's why I prepared a separate PPT which I will then run through and explain you little later. Okay. Now we need to understand very importantly this particular thing. What is that? Please understand carefully. Section 230 provides for compromise arrangement amalgamation. Okay. Now, where a compromise arrangement is proposed between a company and creditor, in case of compromise, between a company and its member in case of arrangement. That's how we need to understand. Okay. So now, in case if it is proposed between a company, either between a company or creditor or between a company and members. Okay. The tribunal here is referred to NCLT. Earlier it was High Court under the provision. On an application of the company or any creditor, on an application of the company or any creditor. Here, arrangement. What is arrangement? This arrangement includes, is a bigger terminology. I'll explain you when I run through the PPT. It's a bigger terminal. It includes merger, demerger, and any form of reorganization. Many things involved. Okay, in arrangement. Okay, compromise, it involves rearrangement or reorganization of the debt. Reorganization of debt is nothing but a compromise. Reorganization of capital is an arrangement. Okay. So it's a bigger terminology. We can't simply understand compromise arrangement very casually. It's a bigger terminology. I'll explain you in detail in subsequent slides. Okay, now when there's a compromise arrangement between a company and a creditor or any class of them, or between a company and its members, the tribunal may, on the application of the company 1, creditor 2, or member of the company 3, please listen carefully. Who can make an application? 1 is company, and 2 is creditor, and 3 is member, or in case of a company which is being wound up of the liquidator. Okay, so that means there are 4 persons, 1 by company, 2 by creditor, 3 by member, or by a liquidator can file an application. May file an application. Order for the meeting of the creditor to be called, held, conducted in such manner as tribunal that. This only triggered, okay? This only triggered, and Honorable NCLAT in important, I will share those case laws, held that and a new, what I would say, chapter or episode has been brought in. Earlier, there was an episode of CRP. First episode is CRP and the Insolvency Bankruptcy Code. The second episode is liquidation. Then the third episode come by way of this particular provision is compromise and arrangement during liquidation. Not only during liquidation, of course, this is permitted even part of the resolution plan itself. I'll show you where it particularly the provisions enables the resolution, the RP to or resolution applicant to give a resolution plan by way of a arrangement, by way of a scheme of merger and amalgamation. I'll show you the definition of it. Okay, so there's a third episode, and the third one is amalgamation or demerger or arrangement in some other in a form by law. Third one. Now the fourth one is what? Sale of corporate debtor as a going concern during liquidation. So now we have got 4 episodes to deliberate, we can say. Okay, 4 episodes to deliberate, which we are practicing also in the court now. Okay, now the third episode, which I said, the scheme that has really came into play because of this particular provision. If this provision would not have been there, then that episode would not have come into the Insolvency Bankruptcy Code at all, where there won't be a provision of class 2B, regulation 2B in the Insolvency Bankruptcy Code. Regulation 2B would have been there. I think I don't think anyway, I'll show in my PPT itself. It is there in my PPT itself, regulation 2B. I'll take this PPT in detail, but still this particular question alone I'll show you. Yeah, that's very important. This particular provision has been brought in by Insolvency Bankruptcy Board to give effect, okay, or to bring in tandem with the provisions of Section 230 of the Companies Act. What compromise arrangement to be in? I'm talking to be IBBA 2016, okay, where a compromise arrangement is proposed under Section 230 of the Company Act 230, it shall be completed within 90 days of the order of liquidation. That means I told you, no, it is coming in between third episode what I referred. That is coming in between episode 1 and 2. In fact, it says CRP. Then the moment liquidation is ordered, 90 days, within 90 days time, if any compromise arrangement is proposed, then that episode should get over. Then only the third episode of liquidation starts. Because of this regulation. Of course, there are supported by various judgments. I'll share you all that in subsequent slides. Where a compromise arrangement is proposed under section 230 of the Companies Act 13, it shall be completed within 90 days of the order of liquidation under subject 1, 2 of section 33. Okay. The time taken on compromise or arrangement not exceeding 90 days shall not be included in the liquidation period. The second one, regulation, subregulation 2. The subregulation 3, any cost incurred by the liquidator in relation to compromise arrangement shall be borne by the CD, where such compromise arrangement is sanctioned by tribunal under subsection 6, section 230. I'll show you that. A cost incurred by liquidator in relation to compromise arrangement shall be CD, where such compromise arrangement is sanctioned by tribunal under section 6 of section 230, provided that such who proposed compromise arrangement where such compromise arrangement is not sanctioned by tribunal under subsection 6 of 230. If sanctioned under subsection 6 of 230, then it should be borne by CD. If not sanctioned under subsection 6 of 230, then it should be borne by the party who is proposing the scheme. Coming to our provision now, PDF. Okay. Now here, coming back to our provision section 230. Okay. Now, by virtue of this amendment, by insertion of that on an application by company or liquidator or see, where at a meeting held in pursuance of subsection 1, majority of persons 3/4 in value of the creditor voting in person or by proxy or by postal ballot agree to any compromise or arrangement, and if such compromise or arrangement is sanctioned by tribunal by an order, then the same shall be binding on company, all the creditors, class of creditors, members and class of members, or in case of company being kind of liquidator. So the moment the order is passed, it shall also bind the liquidator, which is provided under the section 230 of the Companies Act itself. Therefore, the legal sanctity is coming for bringing a scheme under the Insolvency Bankruptcy Code. Okay, after CARP or even during the CARP, I'll share you, discuss with you in detail how it can be brought during CRP, how it can be brought during liquidation, the scheme can be brought in. Okay, so now the liquidator, it also binds the liquidator also. Now what that the class 2B, what we read, it was sounding, the regulation was sounding that the scheme is approved under subsection 6 of section 230, okay, pursuant to subsection 6, then the expense should be borne by the CD. That means the scheme should get a blessing of majority of person representing 3 thing is there, then the expenses has to be borne by the company. If that blessing is not there, still it moves forward with the approval of scheme by the tribunal adjudicating authority, then the expenses has to be borne by the person who is proposing the scheme. This is the clarity that regulation 2B is trying to bring in. So now if you see here, in addition to the liquidator appointed under the provision of Company Act 2013, now by way of insertion, it is the liquidator who is appointed under the IBC code also now covered within the purview of section 230. Not only the liquidator is covered, by way of by means of this particular provision, or I would say by virtue of this inclusion of a liquidator who is appointed under the provision of IBC code, by virtue of this insertion, the new episode of proposing a scheme of arrangement itself has stepped in Insolvency Code bankruptcy, because the originally, if you see the provisions of Insolvency Bankruptcy Code, you can't see the provisions for merger and demerger or arrangement. By virtue of this particular provision, which was observed by Honorable Enclat. In one of the case, the Honorable Enclat says, why not the scheme could be proposed during the liquidation under the Insolvency Bankruptcy Code. Now we are following the process. Now it became the law whereby every liquidator now obligated, they are obligated to follow the process. The moment the company orders for liquidation, if the scheme is proposed, the liquidator should make sure within 90 days he is completing the scheme. This is what the important provision that has got a link between the which link the Insolvency Code with the Companies Act 2013, whereby the scheme itself is getting proposed during the liquidation period. Okay, now coming to next. This I showed you that subsection 6, if the scheme is approved under subsection 6, then cost will be borne by CD itself. If the scheme is not approved pursuant to 6, then the cost of the scheme proposing scheme or even till approval should be borne by the person who is proposing, party who is proposing the scheme. It's very important. Okay. Now coming to again another one. What is this? Now the next point, what we need to, section 249, what it says, recession in making application under section 248. Okay. So for the benefits of viewers, I will show you this. The power of registrar to remove the name of the company from. If the registrar has a reasonable cause to believe that company failed to commence, all these are the grounds where it gives the power to the registrar to remove the name of the companies under section 248. Now, coming to 249, what it says, section 249, the restriction on making application under 248 in certain situations. What are that? An application under subsection 2 of section 248 on behalf of the company shall not be made, because here under section 248 application can be made by company itself. You see, section 248, though registrar is given the power, so a company may, after extinguish all its liability by a special resolution or consent of 75% of member in terms of paid capital, file an application to the registrar for removing the name of the name of the company from the register of companies. So, and also given authority, or they are also given a right to make an application before the registrar after extinguishing all the liability to strike off the name of the company registrar, 248 to remove the name of the company from the register of companies. Now, what 249 provides for? 249 provides for, if an application is made under section 2 of section 248 on behalf of the company, okay, shall not be made, an application shall not be made at any time in the previous 3 months, okay, if the company is being wound up under the insolvency bankruptcy. So this is a very important thing. That means the application under section 242(2) for removal of name of the company shall not be made if at any time in the previous 3 months the company is being wound up. That means the process is initiated under, not only under chapter 20 of the Companies Act, it also under the Insolvency Bankruptcy Code. Then also an application cannot be moved for removal of the company from the register. Okay. Now determination, all this are all omitted actually. To access damage of dealing to all this is omitted. Okay. So you all know that the company liquidator who should be appointed. There are 2 different kind of thing. One is winding up under the Companies Act. The other one, what we are discussing, is a liquidation under Insolvency Bankruptcy Code. In case of if it is a winding up under the provisions of Companies Act, okay, in case of, you all know that in case of commencement of CRP under the provision of section 7, 9, 10 or commencement of liquidation under the order passed under section 33 of the IBC code, you know that the appointment person who is suggested by the creditor or the applicant who is making the application. Whereas in case of winding up under Companies Act, okay, the appointment of provisional liquidator or the company liquidator shall be appointed by the tribunal among the panel maintained, panel of insolvency professional registered with the IBBA, the panel which is the list of insolvency professionals which is shared to the court, means which is shared to the tribunal. The tribunal will, the adjudicating authority will take, even under Companies Act, it is a tribunal. It will take the name, one of the name out of that list, and they will appoint the liquidator or official liquidator or provisional liquidator out of the panel of insolvency professional registered with the IBBA, which list is available before the honorable tribunal. It is also omitted. These are all purely on insolvency. Okay. Now, this also omitted. You must be knowing that voluntary winding up. Now, instead of this, you all know that section 59 of the IBC code has been introduced. And for that sake, this is voluntary winding up part 2 has been removed from the Companies Act 2013. Okay. Now, next coming to the, these are all only purely deals with insolvency. So, application of insolvency rule in winding up of insolvent companies. So, this is omitted by this thing, that rule won't be applicable because we have our own rule. Okay. Now, coming to this particular provision. What is that? Preferential payment. What it says, winding up subject to section 326, there shall be paid in priority to all other debts, all revenues, all that has to be paid. Okay. Now that's why in 53 we are having in IBC code a complete change of section. You can see the complete change in section 327, corresponding to section 59(3) of our insolvency bankruptcy code, which talks about distribution. Okay. Now, if you see this, section 326, 327 shall not be applicable in the event of liquidation. Why? Because there is an equivalent provision of section 53 is available under code. That's the reason they made it very clear that, so that it's clearly excluded. Section 2, 326 and 327 is clearly excluded from the purview of application. Then is another thing, the relevant date, which is for this purpose it is. Okay, now coming to information as to pending liquidations. If the winding up of a company is not concluded within 1 year, we all know that in our similar thing, our regulation, liquidation regulation, wherein the company which is coming under winding up, coming under liquidation, the liquidator shall ensure to complete the liquidation within 1 year. Okay, then otherwise what will happen? Extension has to be given by filing in an annexure of the, giving the detailed report. Extension from adjudicating authority. Similarly, here if you see section 348, if winding up company is not concluded within 1 year after its comment, the liquidator shall, unless he is exempted, within 2 months of expiry, not more than 1 year, means at interval of not more than 1 year, okay, file a statement in such form. So that means every year the liquidator shall ensure an audited thing has to be similar to what we are following under liquidation regulation. Same thing is provided under the section 348 with regard to here. Why this reference of IBC code is coming? Where a company liquidator, after they are getting appointed, who is an insolvency professional registered under the Insolvency Bankruptcy Code 216, is in default in complying with the provision of this section. Okay, if the insolvency, if the company liquidator is default in complying with this section, okay, what is to be done, which I showed you, that they have to make sure that they are filing a audited one every year if it is goes beyond 1 year. Okay, default in complying this particular provision of this section, then such default shall be deemed to a contravention for the contravention of the provisions of the said code. That means whatever provisions provided in the code as contravention. Okay, so even it also equally applicable to the company liquidator who is insolvency person registered under the IBC code. If it's default in complying with this provision, that means since there is no punishment provision available here, they extended the provision which is provided under the code to be applicable to section 348 of the Companies Act. Now coming to next one. Now continuation of pending proceeding. All we know that in the beginning, all that proceeding which was all that was not now got transferred and it was continuing. We all know we have crossed that era now. Almost now every case are coming under the getting filed under the insolvency. Earlier we used to handle at the same time both the case filed under Companies Act and with the High Court and case filed under IBC and NCLT. But now things are now almost settled. Everything come within purview of Honorable Tribunal, unless it is winding up filed under section 270 of the 271 of the Companies Act 2013. Okay. Now, now central government. Now, of course, this is the enabling provision that is given to the government, central government to they are conferred with for the Companies Act, also for the Insolvency Bankruptcy Code. This is very important. That's why the central government is making because if you see the establishment of the National Company Law Board Tribunal itself by virtue of provisions of Companies Act 2013, that you all know that. So now to make sure that that a tribunal is empowered to handle with the cases of Insolvency Bankruptcy Code, the provision has been introduced by way of an insertion here, giving powers to central government to make sure they are conferred with the authority of forming or establishing a tribunal for the purpose of Insolvency and Bankruptcy Code 2016. Now, same thing here. What is applicable under section 424 under provisions of Companies Act? Same thing should be followed by tribunal in matters under Insolvency Bankruptcy. Very interesting to see. Read. The tribunal and appellate tribunal shall not, while disposing of any proceeding before it and appeal before it, be bound. Shall not be bound by procedure laid down in Code of Civil Procedure. Okay, the tribunal or appellate should not be bound by the procedure laid down. They need not to follow the procedure laid down the Code of Civil Procedure Code, but shall be guided by the principle of natural justice and subject to other provisions of this Act, Companies Act 2013, and not only Companies Act 2013, and also the provisions of Insolvency Bankruptcy Code. So here they are trying to link that the tribunal gives an authority not only decide the matters even though the proceeding is filed before the companies are under the provision of Companies Act or under the provision of Insolvency Code. It gives a powers to the tribunal under section 424 that it can go by a principle of natural justice and also subject to the provision. That means they have to make sure to keep it in mind the provisions of Act, not only the provisions of Companies Act and all the provisions of Insolvency Bankruptcy Code and any rule made thereunder. Okay. And the tribunal and appellate tribunal shall have power to regulate their own procedures subject to the provisions of the Companies Act and Insolvency Bankruptcy. That means the tribunal, when deciding certain things, certain process and procedure, they should not only think about Companies Act 2013, they should also think about the Insolvency Bankruptcy Code. That means they cannot say that the tribunal cannot say that they are formed under the provisions of Companies Act. Therefore, they need not to think about Insolvency Code to take any decision and introduce any process. They have to necessarily keep it in mind the provisions of not only the Companies Act and also the Insolvency Bankruptcy Code to make sure they are bringing their own procedure process to regulate. Now coming to next. So the tribunal for the same, the tribunal and appellate shall, for the purpose of deciding under Companies Act or under the same powers as are, they should not dispose the proceeding by following the process of Code of Procedure Code. They should procedure while disposing of any proceeding. Okay, they shall not bound. Okay, shall not bound by the procedure laid down by it. But for the purpose of discharging their function, they have powers of civil code while trying a suit under in respect of following matter, namely. So all these powers the NCLT is having. Even I'm keep seeing in one of the matter, Honorable NCLT, they are directed the registrar, IG registration to give a personal appearance in one of the matter. I happen to see the hearing. They gave a direction to give a personal appearance of IG registration. So I think they derive, maybe they derive power out of this particular provision, whereby they are vested with the civil code power while exercising, while hearing the matters, discharging their function. Okay. Now, same way, they can also, in fact, this is another important thing that we have to see, understand. This is a very important thing that I should not miss out. Section 425. Because this only at least will give little legal protection. I won't say legal protection to tribunal. I would say legal protection to insolvency professionals who are practicing, under IBC. Because unless the orders of tribunal is deemed as a contempt, then nobody will respect. Even otherwise, people are trying to drag and see that they are trying to dilute the whole thing. Okay, but still, since the power of contempt, this means the contempt provision is introduced under section 425 to the tribunal. The tribunal and appellate tribunal shall have the same jurisdiction, power, authority in respect of contempt themselves as a high court. That means the high court contempt power, the Honorable NCLT and the appellate tribunal is having. It's very important one. Because without that, it is very difficult to implement the orders of tribunals, honorable tribunals. Okay, and may exercise for that power under the provisions of Contempt Act, which shall have effect subject to a modification, shall be considered as a tribunal, wherever the court, high court is there, shall be considered a tribunal, appellate tribunal. So that means the power of contempt is very important. The tribunal is having the power of contempt or power to punish for contempt. Okay, as in the case the High Court, Honorable High Court is having under Contempt of Court Act 1971. Okay. Now coming to section 429. Now not only the contempt power, the tribunal The section 429 of the Companies Act provides for or empowers, okay, empowers the tribunal may, here if you say tribunal may what in any proceeding under the Insolvency Management Code in order to take into custody or all property, books of account, request. This is very important. Please understand. Looks like they can't order, but they can request. They can request the chief CMM, we call it, no, Chief Metropolitan Magistrate, CMM, in writing that the CMM or CJM or district collector within whose jurisdiction of property, books of accounts, corporate data are situated to take possession thereof. And the CMM or CJM shall, on request being made, on such request being made. So it is a request, please understand, it is a request to take possession of such property, books, cause the same to be entrusted to the tribunal, other person authorized. So they can, based on request, the CJM can see that they take necessary steps to take the possession of that property, books of documents, and the cause the same to be entrusted to the tribunal and other person authorized. Okay. Now, this is the proceed. I'll take you to another important this thing. Oh, this is the article. We need to that level go into article. Now, coming back to important provision of Companies Act, I wanted to take you through 271 to make it to understand. I'll finish completely the Companies Act provision with respect to Insolvency Bankruptcy Code. Then I will go to the Insolvency Bankruptcy Code and we'll discuss and try to deliberate much detail. Okay. 36, right? Yeah. Section 271, I wanted to take. This is a very important provision which we need to understand under. This only makes entire ball game. This change entire ball game by virtue of this changes, amendments brought in by the IBC code. You all know that Schedule 11 has been introduced, whereby provisions of the Companies Act has been replaced by virtue of introduction of the Insolvency and Bankruptcy Code. Now, let's try to understand the winding up in the context of Insolvency and Bankruptcy Code. Then I want you to take you through the duties of directors and how it differs from Insolvency and Bankruptcy Code. Probably after a break, can we all again gather together? Shall we go on break for 10 minutes? Madam, I'll break for 10 minutes, madam.
Yes, sir.
Okay, ma'am. I'll join after 10 minutes.
Sure, sir.
Shall we start again?
Yes, sir.
Yeah. Coming to section 271, which talks about the circumstances which company may be wound up by tribunal. This is a very important change has been brought in. In fact, I would say rather section 7, 9, 10 of Insolvency Bankruptcy Code, the provision, the enabling provision, which has been carved out from section 271 of the Companies Act. Because those provisions, there was a provision called unable to pay debts. It has been removed by way of an amendment. You all must be knowing that probably. There was one line item whereby there was a circumstances, one of the circumstances was which company may be wound up by. Earlier it was one of the line item was unable to pay debt. Now, after 2016, if you see that unable to debt has been removed as a replacement provision, section 7, 9, 10 has been introduced under IBC code. I'll show you in the PPT what are the sections have been. No, I think in the not this. Oh. This. So these are the amendments to Companies Act by IBC as brought by Schedule 11 of the IBC 2016. Okay. This why in the in fact I took you through all in the act itself actually through each and everything. Okay. Section 66 reduction of share capital we discussed. We have seen in the act itself we have seen and say in the act itself how it is. Okay. 1173, the resolution, I deliberated this particular point, I showed you. Okay. Winding up, inspection report, compromise alignment, this also I discussed. 249, 1E, and this what is omitted I told. 270, yes. Now, coming to this mode of winding up, this is fully substituted. How it is substituted? Okay. Section 3. What is the impact of the provision of company which stand modified as per the provision of Schedule 3? Okay. How it got substituted? Provision was applied to the winding up company under this act. Second, which company may be wound up by tribunal. Okay. Company is unable to pay thing that has to be, that earlier it was there. That means any company, earlier we used to file a winding up. Okay. And under section 433, we used to file a winding up. Okay. I remember so. Okay. Now, the Companies Act 2013 equivalent corresponding section is 271. Okay. Now, if you see the circumstances in which original, before amendment, this is before amendment I'm talking about. Okay, before amendment of Companies Act 2013, by virtue of introduction of the Insolvency Bankruptcy Code, Schedule 11 of the code, earlier the circumstances in which the company may be wound up by tribunal, a company is unable to pay its debt, B, company by special resolution, and C, if the company has acted against the interest of the sovereignty and integrity of India, and D, winding up of the company under chapter which I discussed 19. Application by registrar or tribunal. Okay. And default in filing the financial statement annual return and just an equitable that the company could issue. Okay. Okay. So now this was the original ground. Okay. There was a 7 ground was mentioned. Okay. Now the existing provision of company circumstances specified in class B, class C, class D, and class E and F and G, in which company may be owned by tribunal or retained. So what is now amended, removed? Class A and class D. Okay, winding up company under, because it has now separately dealt with under, no, as I was referring that section 59 has been introduced. Now, if you see, company is unable to pay debt. Okay. So this particular provision, this particular class alone triggered the entire introduction of the section 7, 9, and 10 in the Insolvency Bankruptcy Code. So now, if you see after this amendment, let's see the act, how it appears. See? Now it is removed, unable to pay debt, because now all debt related liquidation are brought under the debt related steps has been brought under the IBC code. And other than debt, everything has been retained under Companies Act under section 271. This is a major difference in the virtue of the amendment and the Companies Act 2013 by virtue of the amendment brought in by Schedule 11 of the Insolvency Bankruptcy. Now, by virtue of the amended one, now the new provision stands that only in these circumstances company can be owned against interest of the sovereignty and by application by registrar, and company has made default in filing the financial statement. And the tribunal is of opinion that it is just an equitable that it should be owned up. So these are the 5 grounds which is retained under Companies Act 2013 under section 271 of the section Companies Act 2013. Now, if any cases which is falling under unable to pay debts has been plugged out and has been inserted in the provisions of the Insolvency Bankruptcy Code by means of section 7, 9, and section 10. This is very important change that has been brought in by the Schedule 11 of the Insolvency Bankruptcy Code within the winding up provisions of the Companies Act 2013. That's very important to understand. That's why I specifically showed this, because this is the very purpose why the Insolvency Code has been brought in separately, because the winding up under section resolution or remedy or release. Okay, that's why the government felt that or credit related matters or the default related matters should be brought under the provisions of separate code, and it should be given a separate focus. That's the reason it has been plugged out and removed from section 271 of the Companies Act 2071. All other winding up is retained under the provisions of Companies Act 2013. Okay, now coming to section 1, we will see now duties of directors. Okay, I wanted specifically because initially one of our friends has started deliberation of directors, suspension, collective wisdom. We all discussed in the beginning itself while starting this particular point before IBC. duties of directors. If you see there, duties of directors subject to the provisions of this act, a director of a company shall act in accordance with the articles of the company. Articles, whether articles still in force when the company is in under liquidation. Can I get your inputs on this? Participants, can you please say whether the memorandum article is perfectly in force for the CD under CRP and CD under liquidation? Anyone? Are you able to hear me? You are there? Very important point which we need to understand before proceeding into IBC code and understand what exactly the provision, corresponding provision between the IBC code and Companies Act. Can you please let me know whether the articles will be in complete force or not? Any hand? Sorry?
They won't be in the complete course.
Okay, partially.
Yeah, partially.
But how to pick and choose?
That I don't know, because the governance power gets shifted to RP. So to that extent, the amendment in the articles is taken place.
No, we are not amending it at all, right?
Amending means the force of the articles gets suspended.
See, that's
Till the
all.
time the resolution takes place.
What got inserted, amended in the Companies Act, I'm almost deliberated to my knowledge. So what ought to have been amended or what need to be amended, probably I wanted to deliberate some time. That's why I'm taking this particular topic. And what are the provisions that still require to be amended? So now, as you said, the powers are suspended. Okay, the law provides powers are suspended. Okay. From where the powers are derived by IRP is directly from the code. You all agree? You all agree? Directly the powers are derived by the IRP, RP and liquidator by virtue of Insolvency Bankruptcy Code. Do you agree? You want to show the provision? It is there in my PPT itself. Can show. See? Management of affairs by IR, it shall vest with the IRP. Powers of board shall suspended and shall be exercised by IRP. And IRP shall have access to all corporate documents and managers, officers shall report to IRP, financial institutions. I'll be a little fast because I have less time. So I want to cover many aspects. So I'll be a little fast in my deliberation. Please, wherever you want to stop me, you can stop me. We can deliberate and I'll move forward then. Okay. So see, these are the powers that have been provided as a management office by IRP under the code. Now, if you come to the section 17(1)(a) of the IBC, which prescribes that on appointment of IRP, the management of affairs of the corporate debtor, and the section 17(1)(b) of the ISP prescribes that on appointment of an IRP, the powers of the board of company shall stand suspended, be exercised by the IRP, and section 17(2)(e) of the IBC prescribe that an appointment of an IRP, the IRP shall be responsible for complying with the requirement of any law on behalf of the city. I got it. So section 17(2)(e) of the IBC prescribe that on appointment of an IRP, the IRP shall be responsible for complying with the requirements under any law on behalf of the CD. Okay. Section 20, subsection 1 of the IBC prescribe on appointment of IRP, the IRP shall manage the operation of the CD as a going concern. This is another obligation. 23(1), if you see, of IBC, that prescribes that on appointment of RP, the RP shall conduct the entire CR process and manage the affairs of CD during CRP period. And same way, section 23(2) of IBC prescribes that on appointment of RP, the RP shall exercise powers and perform duties as are vested or conferred on the IRP under chapter 2. That means whatever power given to the IRP continue to be derived or continue to be performed by RP also. IRP and RP, because the whatever the same, because section 17 provides for IRP. So that means the same power and same obligation RP under section 23(1). Now, if you see section 35, which provides for specific powers and duties of liquidator, but it only provides to take into custody and control of assets and property and actionable claims of the CD and to evaluate the assets and property of the CD and to take measure to protect, preserve. Everywhere it only says assets and properties only. It doesn't talk about managing affairs and even silent about compliance. Okay, and the said provision is do not provide for management of affairs, and that's what we need to understand what exactly that we need to see how to manage the show or manage the process. We need to have clarity on this particular aspect, because the power which has been provided to IRP, RP to comply the law. Because to comply the law, we need to sign certain documents, we need to create certain papers and documents, and we should have enabling powers to do all that. Okay, so which is given to the IRP and RP to make sure to keep the corporate data as a going concern, they have to comply all the laws. Okay, but as much as you see that it do not provide such powers and duties, either for filing return or managing to during liquidation. It's very silent. So from this, what we need to understand. See, now taking you through, let's come to IBC code. Without that, we can't really see. Here, I showed in the PPT. Now I'm showing the provision now, because the important thing I showed there. See, this is what it is. Okay. From the date of appointment of IRP, management of affairs of the corporate data. The powers of the directors shall stand exercised by, okay, the officers manager shall report to IRP and provide access of the document. And financial institution maintain accounts, all that. The IRP vested with the management vested with the management shall act and execute in the name and on behalf of corporate all deeds and reception. Okay. All this is other thing. Important amendment has been brought in that IRP shall be responsible for complying with the requirement on any law for time being force. This has been brought in the code itself under section 17 of the code that IRP shall be responsible for complying with the requirement. Okay, why I am showing this again? I have a reason for that. Okay, now coming to the duties of IRP, the IRP shall perform following duties. Here you see, here it only says management of affairs of CD by IRP. Okay, this entire thing providing for management of affairs of the, so here company has to be run and the affairs has to be managed. Okay, coming to 18, duties of IRP shall perform. What are the duties? Collect all information of assets. Okay, then receive collate all claims submitted pursuant to the public announcement, constitute COC, its operation until RP is appointed. Okay. Just monitor the assets. Okay. This will take custody of the assets which has ownership, all that is there. Okay. These are the routine provisions that we such are the duty as may be stated by the board. Okay. Now coming to, of course, section 19, you all know that the provision is there because government knows while bringing the code itself that the professional may not get a complete support from promoter and others. That's why this particular provision is inbuilt. Okay. But only thing is here, still is it giving a early solution? Then that's again a question only, because unless we get on time the support, it will spoil. See, justice delayed, justice denied. Same thing only. What we supposed to get, that we supposed to get on time. If we don't get on time, what is the use? Something I supposed to get in the year 2020. If I get in 2024, what is the use? Because many things would have been done if it have got in 2020. So anyway, I think we need to see that how to get maximum support from all stakeholders and for managing the process. Okay. Now coming to section 20. Now what we have left out in section 18 for IRP. Here, again, it says preserve the value of assets and manage operations of the corporate data as a going concern. Please see here. It only talks with data. Okay. So for this purpose, the IRP, what are the powers the IRP is having? Appoint a thing to manage the affairs the IRP should have. Okay. So these are the things where prior consent has to be taken. Okay. This and all noted. Okay. So now committee of creditor has to be formed by IRP. Then this process are followed by IRP. After all this process, now coming to RP, it's very important to understand now. So now appointment of RP is taking place by way means of 66%. I thought by showing the provision that will pull your attention more than my PPT. That's why I'm showing this. And now coming to resolution professional to conduct CRP process. Section we had stopped in section 18. Role and responsibility. Okay, from IRP to RP. 23 talks about RP shall conduct the entire affairs and corporate data during CRP period, provided that the RP shall continue managing operations till the after expiry of CRP period also until approving resolution plan. This is an amendment has been brought in and okay. The RP shall exercise powers and duties as are vested or conferred on IRP under this chapter. That means whatever the responsibility is given, whatever duties given, whatever is powers given to IRP is vested. That means the compliance also is vested. What section 17, 18 says that the IRP has to comply, IRP has to manage the affairs of the corporate as a going concern. All that is now conferred by virtue of this provision to the RP also. Okay. Now, in case any appointment of RP, the IRP shall provide all the details. Correct. So now, meeting of the creditor, all that is, the process is followed. Okay. Now coming to duties of RP. Now 25, 18, 17, 18, 23 and 25. This only talks about duties and responsibilities. It shall be duties of the RP to preserve, protect assets of the corporate data, including continued business operations of the corporate data. Whatever the running business, that has to be preserved and protected. For the purpose of section 1, RP shall undertake to take immediate custody of control of assets, which already is given, is continued with RP now. Rise interim finance. This also is already given to IRP, which continued now. given. In additionally, present all resolution plan, inmate resolution applicant. This is additional responsibility given to RP. And now, why I showed this, why we discussed here. Okay. Now let's come here. Okay. Now we can probably see a little later. Now coming to Companies Act. Okay. Now coming to Company, where we have seen duties of RP in under IBC code. Here duties under section 66. Duties of that subject to person shall act in accordance with the article. In accordance with the article. So the director, accordance with the article of the company only. Okay. Now the next one. A director, in order to promote object benefit of member employee. Okay. A director of a company shall exercise his duties. We have got in the code. We have got a code of conduct, and where RP and liquidator, what IP, what they should, how to they should conduct, and how they should is covered in the code of ethic, code of conduct, all that. Okay. A director of a company shall not involve in a situation in which interest that conflicts, possibly may conflict with the interest of the company. I doubt whether liquidator is there or not, because here it specifically says direct, indirect interest that conflicts, possibly may conflict with the interest of the company. Should not involve in a situation. Okay. Now, at fifth, a director of a company shall not attempt to achieve undue gain advantage. Of course, there are provisions built in the IBC code where it says how RP should conduct and the process, how it should be followed, all that is there. Otherwise, what is the penalty or what is the punishment provision also is there if insolvency professional is failed to perform his duty or misfunction, all that is there in the code itself. A director of company shall not assign his office or assignment, and any assignment from it shall be void. Okay. IBB also has brought in this thing that assignment. A contract lacks. Okay. And there in IBC code it is that. Now coming to this. Now here duties of director in accordance with the article of the company. Okay. So articles of the company, even after it becomes a corporate data. Okay. Even it becomes after the corporate data. Okay. Now I'll take you to code now. This is the reason I wanted to show you the code. Now the question here, I need your, undoubtedly I need your inputs, deliberation. Otherwise, we are get a clarity to move forward, then each one is handling our own assignments, then we will only face the situation. Okay. Management of affairs by IRP, which I showed you already. Okay. Here in this, powers of the board of directors or partners, powers of the directors, I can even highlight. Okay. Stands suspended and be exercised by IRP. Okay. And the duty is already given. The duty is already given to IRP. What I showed you, what are the duties of IRP and RP. Okay. Now coming to Companies Act, here it says duties of directors. See, the director of company shall act in accordance with the Companies Act, and he should exercise his duty. These are the duties given. What are that? You see? A director of company. So few in shall act in good faith in order to promote object of the company for the benefit of members of the whole, best interest and employees. Director of the company shall exercise duties with the due care, skill, shall exercise. My question is that whether this duty is also getting suspended under section 17 or not. Our duty still remains with the directors. Because there's a different duties provided in the code to the IRP and RP. Okay. But here on the Companies Act, there's a different duty given to the director. It cannot be assigned by director, of course, by virtue of the law suspends directors. So that's different question altogether. But now, here the duties of director, what we are discussing, is it getting vanished? Appointment of IRP takes place. That's my concern, or that's my doubt point. On appointment of IRP, the duties of directors also vanished or suspended. Suspension is, it's not that completely they are out. Okay, that means their power can, if the court always, they can always take back and question them again. Okay, the two powers. And why particularly powers of a director suspended? Because they have to sign in stuff. There should not be conflict of or conflict of action. Both directors and IRP, RP signing, and so that's the reason the powers of the board's power is suspended. Therefore, the IRP, RP shall exercise that power to manage the affairs of the company. But duties of directors are not suspended. But why then directors are completely kept away and left free? Totally. Any inputs? You have any inputs for this? Or my understanding is wrong? Their duty is also suspended? I showed you everything in front of you. I'm not talking in the air. I'm talking with the showing the provisions only. Please share your views. So that we need to understand, or at least there should be some clarity on this particular point. As a professional, it's our duty also to check certain things with the authorities and give our inputs to the authorities. Then only things can move on. We can't scream inside our four walls saying that nothing is changing outside unless we scream out or we sound out. You have any different view on that? Or do you agree? Duties of directors also suspended. So they need not to worry about section 166. So you have nothing to offer. You will keep quiet. So we can leave board of directors free. You are all ready to take responsibility fully. That confirms, your silence confirms that. As IRP, RP liquidator, we are all ready to take complete responsibilities, powers and duties, even duties of 166 also we are taking. We are taking responsibility of this also because we are rendering the duties of directors only, right? Can we say this stand applicable, stand extend RP? Because they are acting as directors, you are also agreeing the duties of directors substituted to the IRP and RP. That means the IRP, RP of section 166, they are only doing the duties, no? Though duty is given under IBC code, but they are only. That means then IRP, RP only should be responsible. Is it so? So you don't have any. Good. Then enjoy. Directors, duties, powers, whatever that. Let's enjoy. Huh? and face all the. Okay. So this is a provision which I wanted to show to you. Now I'll move on next one. Oh, coming to $230. I wanted to cover so that power to compromise and make arrangements where compromise is proposed. Okay. Now, see, as I was referring, now a separate episode which I called, I said, has been introduced. So I just thought I can share that particular point. Yeah. Now coming to now, actually, okay, you anyone here in the participants handled any corporate restructuring, merger, demerger as part of the IBC? I know companies that many are handling. So I presume none of you handled. So that after my deliberation, you should not say in my case, it has happened, all that you should not say because you are not handling anything. Okay, fine. Now, corporate restructuring is a wide terminology. Okay. Now, this particular thing I would always say under Companies Act, earlier it was in section 392, 395 under 1956 Act. When we practiced before, means present before matter before High Court for scheme, section 392, 395, it was consolidated kind of a provision for entire corporate restructuring. Now, after Companies Act 2013, 1956. We all know that Companies Act 2013, we had a occasion to Companies Act 2013. But nobody would have thought of while bringing the code that merger and demerger could be done under Companies Act also. Means under Companies Act could be done under IBC also. That too during CRP also. So that would be quite surprising, but it has happened. Okay. Today it became a law that merger or amalgamation or demerger can be done not only during CARP, even during liquidation. I'll take you through. Corporate restructuring, all you know that these are the basic elements of these are the methods how the restructuring can be done. I referred you already merge arrangement reconstruction. So demerger, slump sale, these are the things which is possible, which was originally possible under Company Act, today under IBC also. That's what I'm trying to say. Okay. Company law, and these are the authorities which we generally approach for approval under Companies Act 2013. Okay. So, but you see, which we are following under Companies Act 2013, but promulgated on 28 May 2016. After that, things are totally, in fact, if you see, it is insolvency, liquidation, and voluntary liquidation and bankruptcy. So, insolvency and liquidation. So, see, this very specifically says this is applicable. The whole code, the object of the code is insolvency and liquidation. But now, how it got manifested, or I would say that now developed. That's the correct word. The whole thing has got developed in IBC now. Section 230, which I showed you in the Companies Act, okay, which was originally notified December July 2016, which was given effect December 15, 2016. Okay. Now, how this Companies Act 2030 has come into picture in IBC code? In what form? That came into picture in and class 26 of IBC code, where the definition of resolution plan, which means a plan solves the resolution of CD as a going concern in accordance with the part 2. So now in that it is hereby clarified that resolution plan may include provisions for the CD. Okay, that means what is restructuring? Further, it is provided in CD, including by way of merger, amalgamation, demerger. Oh, okay. Including by way of merger. That means restructuring much more is there, which also includes merger. I mean, section definition part of section 5 of 26 says. That means a restructuring beyond merger, amalgamation, demerger also can be done. So under insolvency code as part of the resolution plan. That means a resolution plan can give any kind of a revival restructuring, which can include a restructuring, which can also include any merger, amalgamation and demerger, or any form of restructuring. That's how we need to understand. Anybody, the participant, can you say the difference between merger, amalgamation, demerger? At least this difference can you make out? Because at least we should know all are different. That way we should understand. Is that and demerger all are one and the same? Or is it different? Because today responsibility of submitting a scheme, proposal if it is before as the liquidation order is passed. So now it becomes a responsibility of the insolvency professional that they have to have a knowledge about merger, amalgamation, demerger. Otherwise, if we are not able to understand what is given in the hand, what is given in the paper, which is there in the hand of RP or liquidator, then it is very difficult for liquidator or RP to understand it and explain to the court and what exactly the scheme provides for. Okay, so at least we should have a basic idea of what it is. So you all agree merger, amalgamation, demerger are same. There's no difference. Okay, I leave it with your understanding. I'll move on. Okay. Because since nothing is coming out, so I'm not making further this thing on that point. Merger, amalgamation, because merger, amalgamation, demerger. If this particular word, concept, process, we can deliberate for hours together. That much information is there in that. Okay. But of course, please handle with your own experience, understanding how you understand, so that make sure that all are in compliance with the provisions of not only IBC code, under the provisions of Companies Act. That's more important. So resolution plan, as I was saying, it provides for regulation 37 provides for the resolutions that provide for measures for the resolution of the CD for maximization of value of assets, including but not limited to transfer of all or any part of the assets, the corporate data to one or more person, sale of all or part of the assets, whether subject to any security interest. Now, in regulation also there is a word called restructuring of the corporate data by way of a merger, amalgamation and demerger. Here again same word is taken. So that means the resolution plan shall provide for all this. Okay. So it can be included, but not limited. So it's open. Okay. So it can provide for restructuring of the CD by any of these three methods. Even beyond this three method, any other method, corporate is permitted. That's what it sounds here. Okay. Now, this how it started. The whole thing started, if you, Binani Industries, the Bank of Baroda, where it says that the first or objective is resolution. The second order of objective is maximization of value of assets of CD. The third order of objective is promoting entrepreneurship and availability of credit investment. This was observed by Honorable Enclot in Binani Industries. This is how the whole thing has come. This thing in Swiss ribbon matter under the Supreme Court, it observed. What is interesting to note that the preamble does not in any manner refer to liquidation. That means in preamble, if you see the IBC code, the word liquidation you can't see at all. That's what this judgment, the Honorable Supreme Court says. In the preamble of the IBC code, the word liquidation is not at all appearing, but there's a provision for liquidation. So many sections are there. There's separate chapters are there. Regulations are there, but the preamble doesn't provide for liquidation, which is only availed of as a last resort if there is either no plan or resolution submitted or not up to the mark. Even in liquidation, the liquidator can sell the business of CD as a going concern. This is another important. Even in liquidation, the liquidator can sell the business. So the impetus has been put in this Swiss ribbon matter by Honorable Supreme Court. Impetus for particular matter itself. So now you know that the regulation itself got amended where 32 provides for sale of assets of the sale of corporate data as a going concern. Now it's providing the regulation, amended. Now, next, after that, Honorable Enclot in the matter of S.C. Segan and Amit Gupta, given by Honorable Enclot that we direct the liquidator to proceed in accordance with the law. He will verify, claim all the credit, all control assets, property, action claim, carry on the business as prescribed under 35 before taking steps to. The liquidator will take steps in terms of section 230 of the Companies Act. So this is a triggering point where it says 230 of Companies. So adjudicative circuit will pass appropriate order and only on failure of removal, adjudicator then proceed for the sale of company assets solely. Thereafter, not possible till the company in part or in accordance with the law. Okay. If liquidator initiates, will complete the process under section 230 within 90 days. That's the provision now we can see in regulation 2B, which I showed you. This 90 days only if they have taken from the order. Next, the another matter in Honorable Enclot, the matter of Chevron Prasad and S. Dhanapal. Again, the another direction given by Honorable Enclot, wherein we hold the liquidator to act in terms of the direction of take steps under section 230 of the Companies Act. If the member of CD or creditor and class of creditor approach company through liquidator for compromise arrangement by making proposal of payment to all the creditor, the liquidator will move an application under section 230. Now, this only I showed you the reference here. Because Honorable Enclot took reference from section 230, where that section 230 permits that a scheme can be filed by the liquidator, which also includes the IBC, the record appointed by IBC, when the company is being wound up. So taking clue from here, Honorable Enclot has passed an order stating that the liquidator on behalf of the company will move an application to section 230 before adjudicating national company in terms of observation as made in above. On failure, as observed above, steps should be taken for outright sale of the CD so as to enable employees to continue. This is the order passed in Shriram Prasad versus Dhanapal. This is my own matter. Then again, the subsequent case, Mehal Homes Private Limited, Srinivas. This is another Supreme Court has said. It also does not appear to be necessary to restrict the scope that provision concerning the purpose for which it is enacted, namely the revival of the company, including the company that is liable to be wound up, being wound up, and normally the attempt must be to ensure that rather than dissolving a company, it is allowed to revive. Moreover, Section 391(1)(b) gives right to the liquidator in case of a company which is being wound up to propose a compromise arrangement with the credit. An order of winding up has been made and liquidator has been appointed. So equally, it does not appear question whether in case of company in liquidation, only official liquidator could propose with a creditor member as contributory, or any other contributory or creditor can also come forward with such an application. This it made it very clear the liquidator or any other contributory also can take a steps to provide a. If there's a proposal for a compromise arrangement, a member or creditor liquidator may make an application then proceed in accordance with the act. So while compromise arrangement section 230 proposed, it must be utilized first, then a failure, liquidation under the code may commence. So if you see, and may provide that where a credible proposal is made to liquidator within 7 days of the order for liquidating, that section in 10 days under section 33. A member or a creditor may file an application under section 230 liquidation. If approved by NCLT, the liquidator shall complete the process within 90 days of the order of which I showed you to be. This is nothing but after the order passed by honorable NCLAT. The honorable NCLAT as directed the liquidator to explore the possibility of a scheme under section 230. So the IBBA felt that it is required to amend the regulation to see that to bring the code in tandem with the provisions of Companies Act as well as the order of honorable NCLAT. So cross border is permitted. Yes, it's very much permitted. In fact, I have a separate slide for that. I will show you that cross border merger. Now, coming to cross border merger, then I will take you through a different thing actually. Merger, okay. Where we have so far deliberated on I have deliberated on the compromise and domicile, means within this thing, India. Now, the question comes whether is possible under Companies Act. Same way, cross-border insolvency, is it possible under IBC code? How to make it happen, or is it possible or not? That's the question before us. So this, I try to see that to bring connect between the Companies Act and IBC, where the cross-border merger and cross-border insolvency could be made possible. Okay. So how it got evolved, cross-border merger under Companies Act. September 2013, Companies Act, as you all know, notified. December 2016, the mergers and amalgamation of domestic entity notified. Okay. And April 2017, the cross-border merger, which is permitted under section 2, 3, 4 of Companies Act has been brought into effect. And then subsequently, in March 2018, RBI issued guideline on cross-border merger. So that means the cross-border merger is possible under provisions of Companies Act 2013. Go in detail. What is the regulatory framework for Companies Act? So 230 to 240 talks about, and of course we need to follow SEBI procedure followed. Involved, we need to follow that. And there's a separate rule where companies compromise amendment and amalgamation rule 2016 has to be followed with. Okay. So how it can happen? What is the structure? This is the structure of Companies Act, which I already explained to you, where put it in a table format, where compromise arrangement, which is possible under section 230 and 234. Okay, 234 memorandum mergers and amalgamation with the foreign company, which is notified on 13 May, April 2017. And the compromise arrangement and amalgamation rule came into effect on 15 December 2016. So year by year, we can see the development. Okay, which I showed you, no, which I was referring section 234. It is easy to remember 234. Merger amalgamation company with the foreign company. Okay, now fast track all that. Okay, now coming to normal route, this is a normal how the scheme of approval is taking place, amalgamation and valuation report, all that is taking place. This is a normal route, normal process. How it is followed. Tribunal will fix a meeting and will appoint a chairman. Then notice will be served by the company. Meeting will be conducted. Then scrutiny. Then petition will be filed. Then ROC, RD will give the representation. All that is a routine thing. Now these are the to file in the normal route. Okay, I'm not telling here that this thing. This is a normal this thing. This is a normal process which is for amalgamation mergers. Okay, these are the forms which I told. Now, if cross-border mergers. We are discussing about mergers and amalgamations and demerger. Now, with respect to cross-border mergers, as I was referring 234 of the company's compromise arrangement rule 2016 provides for cross-border mergers, and the same way for 18 provides for So M&A with the foreign companies. As I was referring, these are the a foreign company may, with a prior approval of RBI, merge to company registered under Companies Act, or vice versa. Both the way it is possible. Why we are talking this particular point? Because the resolution plan can provide for and before initiating the liquidation, if there's a scheme or duty of the liquidator to file before the adjudicating authority before initiating the liquidation process, and after exploring that, then to move on with the liquidation. This is what it is. In case the scheme before the liquidator is a cross-border merger, is it possible? Okay, then cross-border insolvency is possible. Then if cross-border insolvency is not permitted, say if cross-border insolvency is not permitted, the cross-border merger resolution plan, same how it would be, a plan could be given before the liquidator. So all these questions comes before us. So that's the reason that we are discussing, or I'm discussing this particular point, particular concept very elaborately, so that it is very important to understand, because we are talking one separate episode. I told you, CARP scheme, then liquidation. So this episode, there's a separate episode in the IBC, which need to be handled by insolvency professional as a liquidator or RP. Okay, so that's very important to understand. Okay. Now, foreign company incorporated outside India may merge with the Indian company after applying prior approval of RBI. Okay, there's a regulation, separate regulation is there. Merge with the foreign company incorporated in any of these jurisdictions. Annexure B after obtaining prior approval of RBI. There's a separate annexure is provided, which is called annexure B. What are the companies in which country? What are the countries where the company is registered can get into the cross-border merger amalgamation. That's very annexure B provides for. Transferring company shall ensure that the valuation conducted by valuer who are the members of the recognized person body in the jurisdiction of the transferee company, not transferor, transferee company. Further, such valuation is in accordance with the internationally applicable. Shall be okay. So the concerned company shall file an application before Tribunal under Section 230. Okay. Now, jurisdiction, if you see about who is having a jurisdiction in case of cross-border merger. So a jurisdiction has not been made sufficient provision in addressing this deficiency, not committed to an action plan developed with the task force to the deficiency. Countries which comes under this list include, so these are the company which I was saying, a jurisdiction having strategic country. These are the jurisdiction referred under section 25A. So if you come to the regulation, FEMA regulation, cross-border merger means any merger, amalgamation or arrangement between an Indian company and a foreign company in accordance with the Companies Compromise Arrangement and Regulation will notified under Companies Act. FEMA for cross-border merger. So this is a regulation for resultant and inbound and outbound. Inbound merger is Indian company. Okay. Outbound merger where the resultant company is foreign company. Okay. For the purpose of outbound merger, the foreign company should be incorporated in a jurisdiction where which is specified in annexure B, which I told. Okay. If you see inbound merger, the resultant company should comply with the requirement of the foreign investment laid down in the FEMA transfer of securities. Okay. But a foreign company is a JV. So these are the regulations which need to be followed in a cross-border merger. So we need to understand very detailed way, then only we can get into the cross-border merger and amalgamation. Okay. Now, a very important question comes, of course, valuation, all that we need to do. As I was saying, internationally accepted principle, we need to do the valuation in accordance with the section 25A of Companies Compromise Arrangement Amalgamation Rule. Okay. So now, if you see any transaction on account of cross-border merger undertaken in accordance with these regulations, shall be deemed to have prior approval of RBI as required under 25A. Okay. Of the Companies Compromise Arrangement Rule. So a certificate from MD or Old-Time Letter Secretary concerned the ensuring the compliance made to the NCLT. So these are the takeaways where cross-border mergers which can happen. Now, cross-border merger. Okay, these are the. See, it's not that easy to make sure that all the foreign companies. Because here, if you see in India, two companies gets merged, demerged. We are getting reports from the regional director, merger from liquidator office, official liquidator. Okay, here, but in case of foreign company from whom we have to take all that. Who is the authority for that and how much time within that time whether it can happen. It works for 2 years from the date of sign transcript to bring result in Indian company. So there are certain guidelines given under FEMA. If those guidelines, then only it is possible under FEMA. So it is very important. One should understand the FEMA provision as well as the Companies Act thing with respect to cross-border insolvency. cross-border insolvency. Okay, this particular case dealt with, because we are talking so far cross-border merger. Cross-border insolvency, the first thing has came out in the Jet. In Jet Airways case, as you know that if you can easily under Google it and see also that initially in India, the Dutch administrative sought to, they initiated the separate insolvency in Dutch court for company's asset. Then the NCLT declared that proceeding to be nullity in law. That means it's not valid. Since the registrar officer Jet Airways assumed that allowing Dutch administrator to proceed in parallel would lead to complications, since Dutch administrator would compete for the same asset, because both person will fight, both the case, the administrator, Dutch administrator, as well as the local RP who is appointed, both has to fight who has to take the assets into control and sell it and sell it and distribute it. So the adjudicating authority was in a different view. Okay. Then after that, it was overturned by Honorable NCLAT on appeal, which permitted, the NCLAT permitted that the continuation of Dutch proceeding alongside the proceeding in India. That means both is possible. The proceeding can take place by Dutch administrator, as well as here the local RPO has been appointed by local NCLT. So here the very important thing is NCLAT permitted the continuation of both Dutch proceeding with the proceeding which is already NCLT proceeding already in India, after securing the cooperation from Dutch bankruptcy administrator. So pursuant to the action of NCLAT, the RP and Dutch administrator mutually agreed upon a cross-border insolvency protocol based on 1997 unilateral model law on cross-border insolvency. You can go through it as a detailed thing is available. Same the case in even video call industry where you can see cross-border insolvency has come into place. So I want to cover one more aspects then before close. Related party transaction, which I thought I should cover very importantly. I should not miss out. Okay. Now I will move on to next one. Now you see, okay, why I have to want to deliberate before closing this? I will take you all to Companies Act. Okay. Wow. Come to Companies Act. Related parties, before that, let me see the relative and related. That will take you to 180. Yes. Related party transaction. Before that, I will take you to related party. The person should be related party. 257 ideally. Take you to directly here definition. Okay. Related party. With reference to a company. This is with reference to a company. Means who are related party? Under Companies Act, director or his relative. Okay, one. 2. KMP or is relative. 3. Firm in which a director, manager, relative is a partner. 4. A private which a director or manager is a member or director. Okay. 5. A public company in which a director or manager is a director. 6. Any body capital whose the board of director, MD, managers are considered to act in direction and advice that. Okay. 7. Any person on whose. Okay. This is the related party definition. Okay. 8. Then I'll take you through IBC. So in 180, related party transaction under Companies Act. Okay. Except with the consent of the board of directors given by resolution. No company shall enter into contract with a related party. Okay. With respect to supply of any goods or material. So sale, purchase, supply of goods or material. 1. Disposing of buying property of any kind. Okay. 3. Leasing of property. Availing or rendering of any service. 5. Appointment of agent. 6. Such related party appointment to any officer. And 7. Underwriting. So this is what provided under the one. And the regular rules provide for it, and it provides for the amount and what is the category. By if we are coming with that threshold, then you have to take an approval. Okay. Provided no member of the company shall vote on to approve the decision, maybe such member is a related party. Okay. With a prior approval company by a special resolution in case of breaching the threshold if the transaction reaches the threshold which is provided. Here it also provides that apply to a transaction entered. That means there's nothing in this section 188 applicable to any transaction entered into by company. It is ordinary course of business. Please carefully note here. It says ordinary course of business. And not on arm's length basis, which are not on arm's length basis. Okay. So nothing in this section shall apply to transaction entered into company in its ordinary course of business other than transaction which are not arm's length basis. That means supposed to be in arm's length basis in ordinary. So this is what the definition provided, means the requirement provided under section 188 of Companies Act with respect to related party. Come to IBC. Now IBC provides for 4 different avoidance transactions. RP and liquidator should understand this because it is very crucial aspects that understand. So there are 4 things. One is preferential transaction, underwriter transaction, external transaction, fraudulent transaction. Detection and filing of this is very important because the requirement of related party and the Companies Act is totally different. You are all having you are all having no inputs to give. Article continue to apply or what is the duties and the powers of RP and director during, though it is suspended, powers are suspended, though you have no answer or no inputs to give. But when question comes to answer, and if I am acting as RP, I have to answer. We can't keep quiet. Let's be prepared. Let's try to understand what is our. So detection and filing is very important aspects and responsibility of the RP. We can't simply and say it is not related party, because here a separate prerogative and a parameter has been provided to deem a transaction as preferential, undervalued, exogenous, or fraudulent transaction. There is no such bifurcation, categorization given under Companies Act, except section 188, which I showed to you, to deem it as a related party. That too with the approval of resolution passed by a shareholder and board, they can move forward, okay, with the related party transaction. But here it's not so. Here we need to understand clear difference, okay. Preferential undervalued and exogenous. Here if you see, these are the 6 types of transaction we need to identify. Preferential transaction 40. Extraordinary credit transaction 50, fraudulent trading 66.1, wrongful trading 66.2. Please understand, these are all separate things that we need to understand. We can't club and see as one. All are different and different parameters. And these are nothing to do with I've told to you and deliberated. Okay. Because here there is no look back period. Here there's a look back period. Okay. And of course, there is process, some approval process is given in the Companies Act. Here it is not so. That's a big party transaction under Companies Act and IBC. Now, very importantly, under IBC, section 20, Committee of Creditors given a right to require the RP to furnish any financial information related. Now, if you see section 25(2)J, I will show you this. Regulation 35A, it every RP has to remember, because this has been introduced by way of notification 3rd July 2018. He has to remember, because during the period of CRP, the RP is mandated, is obligated. 75th day, what he has to do, 115th day, what he has to do, 135th day, what he has to do. This is RP to form opinion within 75 days of commencement, whether transaction is avoidable or not. T plus 75. RP has to make a determination within 115 days of commencement, T plus 115. Okay, whether the transaction is avoidable or not. RP to file application to A within 135 days, T plus 135. Here, if you see, interestingly, the definition of IBC code, I have to show you. Slide 24, definition of IBC code, 524. Because there's a difference between the Companies Act related party and IBC related party. That we should know before. I'm trying to understand. Okay. Here lots of difference are there. 24A deals with the individual. 24 deals with the corporate data. So it is very important that we can't skip this particular aspects under IBC code. Very important. Here, there, where we read related party, where I showed you in section 2, subsection 74, where I showed you in Companies Act, is different. You need to know the minute difference between the both. So section 5, subsection 24, class 24. Under IBC, says related party, a partner, director, partner, or relative. These are all the parties are related party for the purpose of IBC. If this doesn't give any threshold limit which is given under the Companies Act, there is no threshold limit given under the IBC. Here, importantly, a private company in which CD is a director and holds along with the relative more than. It is not so. Okay, that's the difference between IBC and Companies Act. Here, this is a director and also holds. Okay. along with this relative more than 2% of its capital. This is very important. Then public company in which a director, partner, manager and holds more than 2% of his capital. This they took out from, no Companies Act. There's a prerogative of 2%. They borrowed from there. Any body capital whose board of director, manager, who consider same thing what we have seen there. Whose advice, all the same thing what you have seen there. Corporate debtor. This is in relation to corporate debtor. Now coming to 24A. Any person in whom the corporate debtor controls %, of voting rights on account of owning voting rights. In any person in whom the corporate debtor, that also related party. Any person who's control more than 20% voting rate, but on account of ownership. These and all, then IBC not in the Companies Act. These are the difference that we should understand here. J, K, L are different from Companies Act. All these are different from Companies Act. Okay. Now, related party with respect to individual, we are this here again, lot of difference between the Companies Act and here again you see a company in which individual is a director and holds 2%. Here it is important. Where company in which individual is a director and holds along with. Here it only says director. Here relative is not coming. Please, you have to be very carefully. Here director alone is coming, no relative is coming. And holds 2%. This is important. Now come to this part. Okay. So we have seen related party. So now it is important that on or before 75th day, the insolvency committee, RP shall form an opinion whether CD has been subjected to transaction covered under 43, 45, 50, 66. Same way shall make determination within before 115th day and the intimation to the board. Okay, he has to determine transaction whether covered or not. And where RP makes a determination under regulation 2, he shall apply to the AA for appropriate relief on or before 135th day of the insolvency. A very important time frame that we need to keep it in mind as a resolution professional. RP shall submit to the committee along with the detail of following transaction if any observed, found or determined by on professional transaction under section 43, under section 45, external credit transaction 50, fraudulent transaction 6. And now, so these are the sections which we need to keep it in mind as RP to see that we are not missing out any related party transaction, or here we can call avoidance transaction under Companies Act. Where in Companies Act it is related party, in IBC it is avoidance transaction. 43, 44, 45, 46, 47, 48, 50. 51, 66 is very important section, which we can't leave it. These are the general definitions. We have no time to go in detail. That's why I'm skipping this. So, shall be, which is preferential, this alone I'll explain. A CD shall be deemed to have given a preference if there's a transfer of property or interest. Okay, of copy for the benefit of the creditor on account of an antecedent operation debt owed by corporate. That should be a debt. For that, there should not be any transfer of property. In a way, giving a preference. So, the transfer under class A has put the effect of putting such a creditor in a beneficial position than it would have been in the event the distribution of asset being according to 553. So if the same creditor comes in 53 under IBC, what benefit he would have derived? If he's going to derive same benefit or derived the benefit more than what he could have derived under 53, then it is a preferential transaction. Okay. Exception is ordinary course of business. As I was referring, ordinary course of business, arm's length basis, all are coming in the Companies Act. But here, only ordinary course of business, arm's length basis is not coming here under IBC. Okay. So relevant time is 2 years. If it is a related party, 2 years. If it's a non-related party, 1 year. The same thing. Only for 66, there is no look back period for wrongful trading and fraudulent trading. All other, there's a look back period of for related party 2 years, for non-related party 1 year. That we have to keep it in mind. So Ajay may make an application, may on an application made by RP liquidator under section 43. By an order, you can ask the adjudicating NCLT can order for all this. So these are the orders that can be passed in. This is a case law which I have no time to discuss. So avoidance of undervalued transaction. If a liquidator RP as a case may be on an exemption transaction of CD determines that transaction were made during the relevant period, which undervalued, can make an application to adjudicating authority to declare such a transaction void and reverse the effect. Reverse the effect. So, yeah, we shall be considered as undervalued, makes a person or enters a transaction which a person involves a transfer of one or more assets of the corporate debtor for a consideration of value of which is significant by the corporate debtor. Okay. Allowance period 1 year, 2 year, which I told. So this is the application has to be order of the adjudicating authority under section. What can be order passed under section 45? It can provide for, the order can provide for releasing, discharging any security assets, requiring any person to pay such sum, require the payment of such a consideration, independent expert. So these are again, we need to analyze both 45 versus 49, whereas deliberately done or not. These are the difference and all. I'll share the PPT, you can go through less. Corporate data to make exorbitant payment. Suppose the interest is given 40%, 50% interest rate, all that are. Okay. Now these are actions. Okay. Restore. What are the orders can be passed? Here same way, restore the position, modify the terms of the transaction, require any person to. This kind of order can be passed by AA. Fraudulent trading and wrongful trading is very important concept. If during CRP or liquidation it is found that business of CD has been carried out with intent to defraud the corporate debtor, defraud the creditors of the corporate debtor, or for any fraudulent purpose, the adjudicating authority may on application of the RP pass an order that any person who is knowingly party to carrying on business shall be liable to make contribution. Very important thing. Section 66, there is no look back period. Here, even if it have happened 5-6 years before the CRP, then it can be, an application can be filed by RP or liquidator. Next, fraudulent trading. An application made by RP during CRP, the adjudication may by an order direct that a director or corporator shall be liable to make such contribution as it deemed fit if before this he ought to have been known, avoiding the all. He could have must be having an idea about that this will bring the company into CRP. If it have done, then AA will pass order accordingly, applying all this proposition. Things which I thought very important, other things are naturally you can go through. Okay. I'm done with my presentation. If any doubts, you can ask me. Madam, I'm done with my presentation.
If there are any queries, can the participant can ask. Are there any queries? But I think there are no queries. We should conclude. Thank you. So thank you very much, sir, for such a knowledgeable and wonderful session. The session was very insightful. Sir, you are requested to please share the PPTs with us. And all the participants, we are having a perspective on IBC workshop series from Monday onwards. If you wish to attend the same, you can register on our website after clicking on online payment button, and 10 CP are guaranteed for the same. And now there is lunch break till 2 p.m. Next session will start at 2. Preeti ma'am will take the session.
Thank you. Thank you for patient listening. Thank you all. Bye.
Very much. Please share the presentation. Preeti ma'am, shall we start?
Yes, Anjali.
You there?
Anjali, we can start.
Yes, ma'am. I'm just checking if all the participants have joined.
Yes, be sure.
All of you, have you joined?
Yes, we have joined.
Yes, we are here.
Can
Thank
we
you.
start now?
Yes, of course.
Yeah.
Good afternoon, everyone. Nowadays, session will be taken by Preeti Garg ma'am as faculty on interplay of IBC with Arbitration Act and SARFAESI Act. Let me briefly introduce ma'am. Ma'am is a company secretary, advocate, and IT professional. She has a rich experience of more than 12 years as CS and 8 years as advocate. She is IP and registered valuer. She is also visiting faculty of ICSI, NIRC, ICSI, IIT, and RVO. She has also contributed as author for books of ICSI academics on a regular basis. Now I request ma'am to start the session.
Thank you, Anjali. Thank you, all of you. It's a request to all of you. Please switch on your videos because when we are face to face, then it's easy to interact. It's a request to all of you, those who are able to switch on your videos. Pankaj has switched. Thank you, Pankaj. Manish, Mitali, good. Others also, please switch on your videos. At least we can have an interaction whenever we are going with the topics itself, right? Yeah, Nivedita has also on, switch on. Everybody, please, it's a request. See, whenever we are on the online platform, we should always switch on the videos. It's a professional advice that otherwise it's the platform where we can interact with each other. We can get the source of information, not only with the faculty, but with each other also you are being introduced. And later on, if you want to get connect with any of the assignment or any of the advice, they will be the best one to advise you. So it's a genuine request to all of you. Manish ji is agreeing with my statement, right? Thank you. She right. Yeah. Myself, Preeti Garg, Anjali has introduced me. I am an insolvency professional as well as a registered valuer, apart from the basic qualification of being CS and a law graduate from Delhi University. Today, I am going to take up your topic of the interplay of basically IBC with the arbitration and the SARFAESI. Both are playing a connected role with the IBC. Most of us are facing some of the issues when we are playing the role of IP, that there may be the creditors is going for the SARFAESI action. Though it is specifically prohibited under section 14, but still there may be some circumstances where SARFAESI proceeding is always already going on. Various judgments are there with respect to that. To start with, I would like to introduce basically the concept of the SARFAESI initially, and then would like to go ahead with the judgments because the stage at which we are working, these judgments are really of a great help in deciding for whatever issue comes to us. So I generally prefer to go by the judgments before coming to any particular conclusion for any particular issue. Right? Let's start. I am sharing the PPT right now. So this is my SARFAESI, Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act. Anybody who can let me know what is the meaning of securitization or reconstruction or financial asset? Anyone, any of the topic, what we call as a financial asset? SARFAESI is concerned with what? Any idea?
Yes, ma'am. Supposing a bank has given a loan to corporate, then if the bank securitizes it and sells it to another entity like an ARC or any NBFC or anybody else, then it is kind of a securitization. Securitization can also help when an NBFC sells its loans to banks where, so securitization is a method of raising funding. And many a times banks do this or even NBFCs do this. So that is securitization.
Okay,
So I
fine.
think if I can try, so in simple word, recovery of the loan amount by monetizing the collateral and prime security which has been mortgaged with the bank.
Absolutely correct. Absolutely. Right. And basically, when we look for the interplay of SARFAESI with the IBC, we are concerned with enforcement of security interest. This is the part of the SARFAESI which have a role with the IBC. Right? So let's do it initially. You have described it. We all know prior to SARFAESI, there were so many things which were in PIC. RDB Act was there, Companies Act, SICA provisions were there, all were in the giving hands to the debtors. In fact, they were the defaulters, but still debtors were in control of the SSN management of the corporate debtors. There were the committees being set up, Narsima committees or Adhyarujina committees for basically reform in the banking sectors because NPAs were piling up. As NPAs were piling up, a resource was required that though DRT Act was there, which was enabling a separate tribunal was being set up so that banks and financial institutions could approach and get their recovery of their loans dues from there. But still, creditors were not in power. That's why it was being recommended and SARFAESI Act came into force. That was the first time secured creditors were empowered to take steps to recover their dues without intervention of the courts or tribunals. Right? That was the basic thing. Now, how did it act? Let's understand what is the securitization or what is this. First of all, I would like to tell you, this is related to financial asset. So what is a financial asset in basic? It is a contractual right. Underlying word is contractual right, which is giving you a right to receive money in terms of interest and principal repayment. Anything which is giving me, anything which by virtue of the contract is giving me a right to receive money, that I classify as a financial asset. Now, if I look for the banks and the financial institutions balance sheets, whenever they are giving loans and advances are financial assets for the banks and financial institutions. Now, when these loans and advances are given on the verge of the security, it may be a mortgage, it may be a hypothecation, there may be many forms of the loans and advances being given by the banks. Though borrower may repay it in timely, then they are counted as a performing asset. But if borrower defaults, and default is for how many days? To be classified as NPA, default is for
90
how many
days?
Yes.
90 days.
If default is for the 90 days, we classify as a non-performing asset. When it is a non-performing asset, bank itself is authorized to restructure the term of the loans. It can also take the steps to recover the loan, but because the bank is a specialized one in granting the loan, that's why a provision of ARC, Asset Reconstruction Company or Securitization Company was made, which buys basically the non-performing assets when they are classified in the category of loss asset or doubtful assets. Then they are being taken by the ARCs or securitized company. When ARCs or securitized companies are taking over these assets from the banks, it means these loans and advances along with security will go to the ARCs. Now, ARCs will step into the shoes of the banks and will recover the same. Why ARC is important? Because either the bank will be the creditor or ARC will be counted as the creditor of the borrower. When how the ARC is raising funds, here the securitization word is there. This securitized. Now ARC is issuing the receipts to the bank. ARC is either paying the cash or it is giving the securities to the bank in terms of debt securities. And now these debt securities are tradable in the market. The loans and advances which were not encashable in the market, they were converted into the securities to provide liquidity to the banks and financial institutions. So it was known as securitization. How ARCs were raising the funds? ARCs were raising the funds from the qualified buyers. They are basically the qualified institutional buyers. Whenever a scheme is formed to take over the loans and advances from the banks and the financial institution, that scheme is basically financed by the qualified buyers. And then they are issued security receipts in return. These security receipts represent their undivided interest in a particular scheme. So this is basically how, that's why the concept here is that securitization and this is known as securitization of the financial assets, where these financial assets of the banks are converted in terms of securities by the ARCs, which are now tradable and providing liquidity to the bank. Now, what will be the next step? Now, these ARCs will reconstruct the terms of the loan. They will interact with the banks. They will recover the loan from the bank, loan from the borrower. But if the borrower is defaulting, if the borrower once agree and further defaults, what is the course of action available? The course of action available is then the enforcement of the security interest. Means this security will be realized by the ARCs or the securitized company. They will be sold through the auction and the amount of the loan will be recovered. For this purpose, there is no need of any tribunal permission. There is no need of anyone else. This step can be taken by the ARCs or securitized company just by giving a notice of 60 days. So this is, now look for what is the objective of the act. The act was to regulate securitization and reconstruction. I think now the word securitization and reconstruction is clear. Okay. Then is the enforcement of the security interest. Apart from that, we all know a separate SARFAESI was being set up. The objective was that whenever the banks and the financial institutions are giving loans and advances on the basis of a security, they must be registered with some institution, and that institution was known as SARFAESI. Right? So that is the central database of security interest. Right. There were the conditions that were to take the shelter of the SARFAESI. There was a conditions being mentioned in section 31. First of all, there is a difference between IBC and SARFAESI, that SARFAESI is available to banks and financial institutions only. One thing is this. Then it is available only when the debt is secure. Third thing is SARFAESI is not available unless and until debt is classified as non-performing asset. So these things are there which are not being required in the IBC if one wants to go ahead for the recovery. But the difference is SARFAESI is meant for the recovery of the loans, while IBC objective is to revive the corporate debt. So this is a difference between the two acts. Plus, if one wants to take action in the SARFAESI, outstanding dues must be 1 lakh and above, and more than 20% of the principal loan amount and interest must be pending. Only then an action under SARFAESI can be initiated. Agricultural land is being protected. If agricultural land is being given as a security, no action under SARFAESI is available in respect. So this is one, briefly some of the points of the section 31, which are stating that these are the requirements to take action under SARFAESI. Right. If we go ahead with the bird eye view, this is a preliminary. Write everything. One is giving, first part will give you the objects and the applicability. Then second part is giving you how to regularize it, basically, which is related to ARC. We are concerned with this enforcement of security interest when we are dealing with the interplay of IBC and SARFAESI. This is one thing to note. When SARFAESI came, it came in 2002, but its constitutional validity was tested under Mardia Chemicals, and finally in 2005 it came into force. Supreme Court has held that yes, though SARFAESI was recognized as a draconian law because it is giving a straightforward hand in the forward way out in the hands of the banks and the financial institutions or ARCs that to take over the asset straightforward and sell it and realize it. But it said it is required because NPAs were very high at that time. The only thing that was being repealed, that was being stated that it is not correct, was that whenever an appeal was required in SARFAESI, at least 75% of the amount was required to be deposited. This was the only provision that was being objected by the Supreme Court. Apart from that, everything in the SARFAESI was held to be constitutionally valid after Mardia Chemical case. So this Supreme Court found that requirement of deposit of 75% of the amount under Section 70 is onerous and it is oppressive. So later on, it was converted to 50% and it can further be reduced to 25% if DRAT consider it fit for the same. It has also provided for the establishment of the ARCs, where how the NPAs are being classified if interest or principal is due and payable and is not paid for 90 days. It is NPA. Then it is a substandard asset if not paid for next 12 months. Further, in between 12 to 48 months, if not paid, they are doubtful asset. And apart, if further left out for 48 months above, they are classified as loss asset. Banks and financial institutions take action at this point of time. When any particular NPA fall in the category of doubtful assets, then banks and financial institutions starts initiating action under SARFAESI. This act is applicable for banks and financial institutions benefit, but it is not applicable against the rural bank or this. Means if some bank is making the default, no action under SARFAESI is available for against the banks or the financial institutions. Some of the definitions are there, which are relevant for the purpose of our judgments also. One is basic thing is what is asset reconstruction. Asset reconstruction means whenever an ARC is acquiring any interest or right of the bank or financial institutions in the loans and advances given by the banks. And the purpose here is to realize the financial loan. See, the purpose of asset reconstruction is to realize the loan given by the financial institutions or banks. Then we call it as an asset reconstruction company. In some of the judgments, cooperative banks were held that they are not falling in the definition of banks. So they cannot take action under SARFAESI. But again, if we go through the definition of the bank, it takes banking company, new banks, SBI, subsidiary, multi-state cooperative, or any other bank which may be notified by the central government in this respect. Now, what is the meaning of debt security? Because ARCs issues to the banks and the financial institutions debt security in exchange of their loans and advances. So these are basically debenture securities kind of things which are listed in the SEBI market. Now, action, whether it be in SARFAESI or in IBC, it can be taken only when if there is a default, and default is of a threshold limit that is being specified in the respective acts. In this case, SARFAESI says if a loan is classified as NPA, then it is a default. But if it is a case that debentures are being issued and they are not being paid, then debenture trustee will serve you a notice for the non-payment of the debt, and then it will be called after the 90 days of the notice. If it is not being paid, then it will be counted as a default in case of debenture securities also. Now, what is a financial assistance? Bank can give a financial assistance in form of loan or advance, right? If any debenture or bonds are being issued by any corporate, bank can subscribe the same. Bank can given the guarantee. It can given the letter of credit or any other credit facility for the purpose that the corporate debtor or any other person could acquire either the tangible assets or intangible assets or any right or interest or title in the tangible assets or intangible assets. Now, the word here is obliger. Obliger is a person who is under an obligation to pay. And this obligation may be contractual obligation or it may be otherwise out of the contract. But he is under an obligation to pay. Originator here is the banks and the financial institutions who are giving the loans and advances because they are owner of the financial assets. And what kind of property is given as a mortgage? It may be an immovable property, movable property. It can be any debt or right to receive money. It can be any receivable or the intangible assets. Only secured creditor can take action. So who are falling in the category of these secured creditors? Banks, financial institutions, or it may be a group of banks or the constitution or the financial institutions who are having joint rights over the asset that is being given as a security for the purpose of loan. Debenture trustee may also be recognized as a secured creditor. Any ARC which steps into the shoes of banks or financial institution is also treated as a secured creditor. If bank has issued security interest in favor of a trustee, then the trustee will be counted as a secured creditor. Now, one of the question is whether NBFC is also permitted under SARFAESI. The same question I ask you, whether NBFC is permitted in IBC to take action, whether or in IBC financial service providers are being excluded, but whether an action against NBFC be taken in IBC? Can any action against NBFC be taken in IBC? Any idea about that?
Ma'am, it's DHFL.
Yes. So that was a circular being issued in 2019, which states that NBFC, which are fulfilling some of the criteria, they can be subject to the insolvency proceedings in IBC. Similar way, in 2020, there was amendment in SARFAESI Act, which states that NBFCs, which are having assets of 100 crore in the last audited balance sheet and debt of 50 lakh and above, they can enforce the security interest for those debts which are falling in the category of 50 lakhs and above, right? Now, what is a security interest? Security interest can be created any mortgage, charge, hypothecations on any tangible assets, or sometimes like the hypothecations, EMIs we are getting on the installments of the car or the scooter or the house, or then it could be a financial lease which is supporting me to acquire a particular asset. Or if anybody wants to acquire any right title interest in intangible assets, that defines the right title or interest on the intangible asset is also counted as a security interest. Security receipts are issued to the qualified buyers. In return, they are financing a particular scheme of taking over loans and advances from the banks. And that whatever the receipts being issued by the ARC to the QIBs, if you remember this chart, if you would keep this chart in mind, this. Whenever the funds are raised, ARC are issuing them the security receipts. These are the receipts which are giving an undivided interest to these QIBs in that particular scheme of taking over these loans and advances. So this is basically about this. Now, when I look for the SARFAESI, SARFAESI cannot be exercised against a lien. Goods may be kept. Lien is a possessory right. There is no ownership with respect to those goods, but lien is being authorized by the Indian Contract Act. An unpaid seller can exercise the lien for the amount unpaid under the Sales of Goods Act or any other law for the time being in force. One thing here is that it does not apply to any rights of unpaid seller. Unpaid seller means an operational creditor under IBC. So IBC is authorizing operational creditors to initiate the recovery process or to initiate CIRP in IBC, but SARFAESI is not allowing an operational creditor to take any action. It is only for the financial creditor. That is banks and the financial institutions, which can take advantage of the SARFAESI. This is a very big difference between the SARFAESI and IBC. That SARFAESI is meant only for the financial creditors. Again, the provisions of the CPC that some of the things which you can never take from any person, though it has made a default of whatever level, because that person as a human has a right to live for. The same thing if we look for in the IBC, that is also given under the Individual Insolvency Act of the IBC Part 3, that those which are religious ornaments or which are tools required to earn the money, they cannot be taken over. Pension funds cannot be taken, wearing apparels, basic necessities, they cannot be taken over even in SARFAESI, neither in SARFAESI nor in IBC. Similarly, if any security interest is created over the aircraft, then that cannot be taken over under SARFAESI. Just like the significant shareholders in the companies, SARFAESI recognized sponsors with respect to the ARCs. It says the persons who are holding at least 10% of the equity share capital of ARC, they are categorized as the sponsors. Like the Every Act, the tool has been given that civil courts have no jurisdiction to entertain any suit or proceedings with respect to any matter which is being covered under this particular SARFAESI Act. And an overriding clause that this provision of the Act shall have an effect is notwithstanding contained any other in law or an instrument affected by the law. The same wordings are there in the IBC under section 238 also. If I say whether Limitation Act is applicable, yes, Limitation Act is applicable in SARFAESI also. Just like in IBC, we look for the 3-year period. Similar is the 3-year period being looked for in the SARFAESI also, along with the other provisions of the Limitation Acts. Now, whether SARFAESI is an exclusive act to be dealt with, no. This is giving you a remedy in addition to the remedies being provided under the Companies Act. Now it's 2013, Securities Contract Act, 1956, SEBI or RDBFI Act. Now it is Recovery of Debt and Bankruptcy Act. That is not, but means they can also be taken along with the SARFAESI. A secured creditor can take actions under these particular other laws also. Now, in these two important aspects of the SARFAESI, securitization and reconstruction is basically an operational part of the SARFAESI. We are concerned here with now how the security interest be enforced, and if it be enforced, can secured creditor go or the corporate debtor go in the IBC? Can CIRP be admitted at the time when any proceedings under SARFAESI is going on? These are some of the questions which have come in various judgments, and then which will override. IBC will override SARFAESI, or there is a scope for the relief under SARFAESI. In SARFAESI, it is section 13 which plays an important role when it comes to enforcement of security interest. How it plays an enforcement role, that we know in the Transfer of Property Act, which is basically dealing with the mortgage or of the immovable properties, it states that if any immovable property is mortgaged, still civil court's permission is needed so as to sell them. But SARFAESI section 37 specifically states that it is overriding section 69 and 69A of the Transfer of Property Act. It states that if any security interest is created in favor of secured creditor, it can be enforced without the intervention of any court or tribunal by such creditor in accordance with the provisions of the Act. It means if the Act's condition of the specified in the Act is being satisfied, then he can take over the secured asset, sell it, and realize his loan and interest due on there. So whenever any borrower is under a liability to pay to a secured creditor and he is making a default, and then default is classified as NPA. So the condition is first of all default with respect to the secured debt, then that being classified as NPA, then secured creditor has to give a 60 days notice to the borrower that if demanding the payment and specifying that if payment is not made, he will enforce the security. Now, contents of the notice are same, that he will say this, details of the amount payable by the borrower, and if the same is not being paid, then it will be taken over by, secured assets will be taken over by the banks or the financial institutions. Now, in this case, do borrower have a right to say anything? Though as such, it is not compulsory for him, but if we make a representation to the banks or the financial institutions, or we say secured creditor, then secured creditor is under an obligation to consider the same representation or objection. And if after that he comes to the conclusion that such representation or objection is not acceptable or it is not tenable, then he shall, the underlying word is shall. So it is compulsory for him to communicate within 15 days that this representation is not being accepted. whatever be the communication by the secure creditor at this stage of time, that shall not be have anything related to further in any proceedings with the DRT or DRAT. Now, what the course of actions available to the secured creditor? What he can do? He can take over the possession of the secured assets. Even he can give that secured assets on lease. He can assign that secured asset. He can sell that secured asset for realizing. But the law says the right of transfer by lease, assignment, or sale shall be exercised when it is on a business. Then, or if the substantial part of the business is being held as a security, only then it shall be exercised. He can take over the management of the business. If I say in IBC, the business is under the IRP. So if a corporate debtor is admitted in IBC, this action cannot be taken. Or if this action has been taken, what will be the course of action available? This is where some of the conflicts are there in, say, this SARFAESI and IBC. Whenever but if this action has been taken of transfer or something, finally, the third party is not going to be affected later on. If before any course of action under IBC, the assets has been sold or given on lease or management has been taken over, then they cannot be further affected by the IBC. If the borrower fails to discharge the liability, he can appoint the manager for the same also. He may require by notice in writing that it may be that borrower has to take money from some other one, third party. Then SARFAESI is empowering the secure creditor to write to third party that whatever amount you have to pay to the borrower, you pay it to me because I have to take money from the borrower. In that case, if the payment is made by the third party to the secure creditor directly, it will be a discharge for him for the liability with respect to the borrower. Sale proceeds are to be appropriated. It is just like in the IBC or anywhere we see, first of all, cost, charging and expenses will be set off. Then second, the debt of the, whatever be the debt amount due to the secure creditor, that will be taken, that will be discharged. And then whatever will be left out, it will be paid to the person who has given that asset as a security. But what happened if it is an asset of the company and it goes in liquidation? In IBC also, the workmen rights are being protected and they are at the second rank in section 53, standing pari passu with those secure creditors who have relinquished their security. Same thing is being mentioned in SARFAESI also, that if the company is under liquidation and secure creditor is realizing his security, he has to pay a proportionate amount to the workmen's dues. The same thing, the same pattern is in the later IBC being followed. Section 13.8 of the SARFAESI was being introduced by way of amendment, which states that if the borrower is ready to pay to the secure creditor his amount due along with the cost charges incurred by him before the date of publication of notice for public auction or inviting the quotations or tenders, before this is done, then secure creditor cannot further go and go for the lease or sale. And if he has taken any step, he will stop there itself because the borrower is ready to take the secured assets and make the entire dues which are there with respect to the secured creditor. So this was basically an amendment that has been there of section 13.8. There was an amendment by IBC in SARFAESI by way of 7th schedule. And in some earlier, what was happening that if a particular loan was given to a particular borrower by more than one bank, so it was a consortium loan. So any of the action regarding the taking over the possession of the secured assets or the management or appointing a manager or receiver, it has to be taken with the consent of at least 60% of the value of the secured creditor. But when IBC came into pic, it introduces a change and it says that this whole clause of taking the action is subject to the provisions of the IBC. So if an action under IBC has been taken over, then the SARFAESI action under SARFAESI cannot be taken by these consortium banks. Similarly, can a secured creditor in SARFAESI take action against the guarantor? The same question was in IBC also, that if a resolution plan is approved, corporate debtor is discharged, so a guarantor should also be discharged. But the thing was not being accepted in SARFAESI also. They said that it is not necessary for a secured creditor to proceed against banks, proceed against the borrower. They can directly proceed against the guarantor also. They can sell the pledged assets also without requiring any of the action. Means these are the options available to the secured creditor, that they can take over the asset and directly sell it, or they can take over the management, appoint a receiver, and sometimes they can take directly the action against the guarantor also. So it is not a new concept in IBC that the action against the guarantor is permitted. This is coming directly from the SARFAESI also. Borrowers, just like section 14 is prohibiting the corporate debtor from alienating the assets. Similarly, SARFAESI is also restricting the borrower that he cannot touch upon the secured assets without the written consent of the secured creditor. And the natural justice rule will be followed. So is there no role of any machinery, any constitutional machinery in it? No, there is definitely a role, because to take over the possession, though the secured creditor does not need any permission, but he needs some assistance to take over the possession. Who will provide him the assistance? He can write to the Chief Metropolitan Magistrate in case of metro cities, or to the district magistrate within whose jurisdiction the documents or the immovable properties are lying. And they have to pass within 30 days from the date of applications. They have to pass an order, provide the police assistance to help him to take over the possession of the secured assets. And 60 days time period may be, the time that can be taken in giving such order can be 60 days for the reasons to be recorded in writing. But for the Chief Metropolitan Magistrate, what he is required to be satisfied by the borrower. Borrower has committed default. One thing he has to be sure, yes, financial assistance was given to the borrower and that was being defaulted. Then the account has been classified as NPA. Plus a 60 days notice has been served. If these three conditions are being satisfied by the borrower, then Chief Metropolitan Magistrate will give an assistance to take over the possession of the secured asset. Then the objective was they have set up a central registry, which is known as SARFAESI. Now it is being mentioned that unless and until any particular loan with the given on a security is registered with the central registry, no action under SARFAESI is available. Very clear cut mention that whether it be the securitization transaction, ARC or security interest, it shall be registered with the SARFAESI after the establishment of SARFAESI with effect from 24th January 2020. And how they will be prioritized, just like section 53 in the IBC is giving a waterfall mechanism, how the liquidation assets will be distributed, proceeds will be distributed among the stakeholders. Similarly is section 26 capital A, which is saying that a secured creditor who is registered under SARFAESI will be the first priority for at the time of repayment. The one who has registered itself first will get the payment first. But if insolvency proceedings are initiated, then this priority will not prevail. Priority under IBC will prevail. Specifically stated, so if I go by the various provisions of SARFAESI itself, like section 13, subsection 9, which is subject to the provision of IBC. Similarly, here they are saying that this priority of distribution is subject to IBC. So these changes being introduced in SARFAESI is a clear indication of the legislature that whenever there is a conflict, I'm underlining the word whenever there is a conflict, then IBC will prevail. This is what an interpretation from these particular sections. Now, what are the measures of recovery in SARFAESI? Do borrower have no right? He has a right. How? He can go against the measures to recover the secured creditor debts to the DRT within the 45 days of the grievance cause. Then that has to be disposed of within 60 days to maximum 4 months. If not satisfied, either the secured banks and financial institution not satisfied or borrower not satisfied, they can file an appeal with the DRT within next 30 days. But DRT will entertain this appeal only if 50% is being deposited. So at least 50% is recovered for this appeal if it is filed by the borrower. So whatever the amount decided by the DRT or the claimed by secured creditor, whichever is less, 50% of that amount shall be deposited to further go ahead with the appeal. And DRT on just and sufficient cause can reduce it to 25%. So this is basically regarding the brief introduction of the SARFAESI. Now let's analyze the SARFAESI through the judgments and a brief introduction of the IBC, those provisions which are relevant for the SARFAESI basically. So if I go for the IBC provisions which may have a conflict with the SARFAESI, it is basically SARFAESI is for the financial creditors. So it is section 7 that is relevant of the IBC for me. So this is a brief history that we all know about the SARFAESI. Let's see this. IBC is a basically two-stage process. The objective of IBC is altogether different from SARFAESI. SARFAESI is a debt recovery mechanism in the hands of the banks and the financial institutions. But again, IBC starts, first of all, there shall be a default. Debt due becomes payable and not paid. Then default limit is with effect from 24th March 2020, it is 1 crore or more. If I look for the preamble, it is reorganize and resolve the insolvency. So it wants to take over, resolve the insolvency is the objective with the maximization of the value of the asset. It is not a debt recovery mechanism. It is a revival mechanism, basically. This is applicable to the companies. LLP, parts are being defined, and companies, LLP, body corporates are falling in part 2. Personal guarantors may be in part 2, maybe in part 3, depending upon at which stage the proceedings are initiated against the personal guarantor. Partnership firms and other individuals are in part 3. Now it is saying corporate person means a company as well as an LLP having or any entity which is having a limited liability characteristics, but it is excluding the financial service providers. So even in IBC, we cannot take action against the financial service providers. Who is falling in the category of financial service providers? The banks and financial institutions are falling in the category of financial service providers. But like DHFL, actions was initiated because a circular came which states that NBFC with asset size of 500 crore or more, as per the last audited balance sheet, can be subject to IBC, but there the regulator will be RBI. RBI has to give a no objection criteria for the ultimate resolution being passed. RBI has to give a no objection for the application of IBC being filed with respect to these NBFCs. The difference between the SARFAESI and IBC is, SARFAESI is talking about only the secured creditor, while IBC is taking creditor as a financial creditor or an operational. So it is considering the both aspects of the financial assistance granted to a corporate debtor. Financial creditor is the one who is giving a financial debt, financial assistance to the company. And operational creditor is the one who is giving assistance in the operations of the company. So that is classified under the operational debts. Now, who can initiate CIR? In SARFAESI, only secured creditor being banks and financial institutions were permitted, but IBC is giving a wider scope. It is saying financial creditor, operational creditor, and even the company itself can come and initiate CIR. That was basically being granted here. And what will be the effect of admission of CIRP? Effect of admission of CIRP is moratorium. This is specifically stated in section 13 that once an admission of CIRP is there, the three things are going to happen. First of all, a moratorium will be declared, then a public announcement will be made, and an IRP will be appointed. If I go, this is section 14, which is creating the biggest conflict between the SARFAESI and IBC. All the things are revolving around this moratorium concept. Because once CIRP is admitted, there is a prohibition for the institution of suits, continuation of pending suits, and then the proceedings. And underlying word here is against the corporate debt. So it is not prohibiting anything which the corporate debtor has initiated any legal action. It is prohibiting those legal actions which are against the corporate debt. One thing to be clear that this moratorium is to protect the corporate debtor from those legal actions which may impact the corporate debtor assets or the liabilities. And even this is prohibiting if any judgment, decree or order has been there in the court of law or tribunal or the arbitral panel or any other authority, giving a wider scope. Nothing can be implemented against the corporate debtor. Then corporate debtor itself is prohibited to touch upon its own assets. It cannot alienate or transfer the assets. Third clause that is important is that no action to foreclose. Foreclose means that they have taken the immovable assets and now they have debarred the borrower from taking any action to recover their secured asset. It means even because a borrower is permitted to take over his asset back by paying all the dues before the public auction announcement is there. But this IBC says that even if any such public announcement has been there and the company is being admitted in the CIRP, further no sale can take place in SARFAESI. This is what is my interpretation of section 14 with respect to SARFAESI. Any recovery proceedings are being meant for, they will be stopped itself. They want to sell, they have taken over the possession assets, the auction is there, they are in the process of sale. That will be stopped. Status quo has to be maintained. Then again, if any property has been taken on a rent by the secured creditors, they cannot, any corporate debtor is using any of the property for its own office or the factory itself, they cannot be taken back during the moratorium period, provided the payment, their rents are being paid for the CIRP period as and when they are due. Similarly, essential goods and services cannot be stopped for the corporate debtor. And they are giving an exemption for those agreements and arrangements which are exempted by the central government. And this is with respect to aircraft. Central government has notified that moratorium, if the aircraft are given as a security, they can be taken back. Moratorium is not applicable with respect to them. Then again, because SARFAESI was also permitting to take action against the guarantor, similar way IBC is also permitting to take an action against a surety in a contract of guarantee. Both are same at this point of time. So whenever this moratorium comes into pick in various judgment, one of the thing was this moratorium is not indefinite. It has a life. Now, what life does it have? It starts from the date when CIRP commences and it ends when the CIRP is completed. Now, CIRP may be completed even before it's this time period of 180 or 270 days or 330 days, whatever is there, or any time whenever the dedicating authority approves the resolution plan or it is being admitted for the liquidation. This section 14 comes to an end. One thing to be clear that this section 14 has a life till the order of approval of resolution plan or liquidation or CIRP phase. Till it is there, then moratorium ends. After that, action will be revived back. but only those actions which are against the CD. This again underlying word is moratorium is against prohibiting the actions against corporate debtors. So the moratorium has been defined. NCLT in the P. Mohan Raj others case has taken this into account, where the Supreme Court had ruled that a moratorium is imposed to protect the corporate debtor from financial attacks in order to give it a breathing room, so that because we want to run it as a going concern and eventually recover it. So during moratorium, they are being protected from being sued or any legal actions which is taken against them. That may be a judgment, decree, or order. So the intention of the moratorium, imposing the moratorium, was made clear by the Supreme Court in this P. Mohan Raj case also. This is the timeline that we all know about it. We will discuss it a little bit if required. And then comes the liquidation process. Is there any moratorium applicable if the company is admitted in liquidation? Please tell me, is there any moratorium in liquidation also? Anybody? We are talking during CIRP moratorium is there. But if the company is admitted to liquidation, is there any moratorium?
No, ma'am, it's not there.
It is there. In section 33, subsection 4. In section 33 has listed out some of the situations. In subsection 5 of this is saying that subject to section 52, whenever their liquidation order is passed, no suit or other legal proceedings shall, now it underlying word, read it carefully. No suit or other legal proceedings shall be instituted by or against the corporate debtor. What is the difference between this section 14 moratorium and this section 33 moratorium? What is the difference in the language? See, when we read section 14, it is saying against the corporate debtor. So if an action is taken by the corporate debtor for its own benefit, that is permitted. But when we talk about this section 33 concept, it is saying neither the corporate debtor can take action nor someone else can take action against the corporate debtor if a company has been admitted to a liquidation. But it has an exception that with the prior approval of the adjudicating authority, if liquidator wants, it can initiate any suit or legal proceedings on behalf of the corporate debtor. And these legal proceedings may be initiated with respect to those transactions that central government may notify in consultation with the financial sector regulator. So these are the 2 points of the moratorium. So once a company's corporate debtor is admitted into CIRP.
Ma'am, can I
Yes,
ask one
yes,
question, please?
yes.
Ma'am, then PMLA in liquidation proceedings, does not allow the corporate debtor or the liquidator to take the possession, and there are so many litigations which are pending. Is there any solution for all such cases?
The solution is, we all know whenever the acts are made, everything is made and they are practically implemented. Still, there will be confusion remain. Conflicts will remain. PMLA has its own overriding clause. So ED will go accordingly. But IRP is under a duty to protect and preserve the assets of the corporate debtor. So IRP has to play his role under the IBC. That's why it is stated these conflicts will go on, but if we are aware of the wordings of the code itself, where we are working, because as an IP, I will protect myself. And as an IP, if I have to protect it, then in that case, I will go by these wordings. I literally read these wordings very carefully while demarking the difference, that if in PMLA ED comes to me and asks for the possession or he doesn't give, I will say that you cannot initiate any legal proceedings against me. Because there is another moratorium in the liquidation. And a beneficial hand is being given in the hand of corporate debtor. That if you want, you can take it to protect and preserve your assets. to maximize the value of your assets.
Thank you.
And even in PMLA, you will see there are in almost all the cases it has been held that whatever be the claim of the ED, he can come as an operational creditor. He can file the claim as an operational creditor, but he has to give the possession back to the IRP or the resolution professional. Now, when I talk about section 52 of the IBC, it is giving a free hand just like the SARFAESI. Though it is giving a free hand to all the secured creditors, and SARFAESI is restricted only to the banks and financial institutions. What it is saying, yes, like the SARFAESI, if you want, you can relinquish the security interest, give it to the liquidator, and be a part of waterfall mechanism under section 53. But if you want yourself to realize the security interest, then you have to inform the liquidator that I want to realize the security interest. And to realize the security interest, he has to prove his security interest. He has to prove, yes, on this asset, I have a security interest, and this may be reflected from the information utility record. And now they are being registered, so SARFAESI is also there to help out them. Yes, they have a record right over those secured assets. They can take over those secured assets and realize it. Then he can enforce, realize, settle, compromise this in accordance with the law applicable. Means even if a company is under liquidation, now another question is, can a secured creditor take shelter in SARFAESI for enforcing the security interest during liquidation? Yes, if he is not, because this is giving a free hand. It is saying, okay, you want to take over the asset, you can take it in accordance with law, which is applicable to the security interest. So if banks and financial institutions want, they can go ahead according to that also. And then they will apply the proceeds to recover the debts due to it. Now, if CD doesn't give means he is not able to get back the possession of the secured assets, to whom he can approach? NCLT is the authority. In a CIRP, if a corporate debtor is admitted in CIRP, if any resistance is faced, then one can approach the adjudicating authority also. And then adjudicating authority has to give the decision with respect to the realization, and whatever be the excess, it has to be returned back. Excess amount has to be returned back, and the shortfall, then section 53 is there, in which he will fall pari passu in rank with the government. What additional steps are required for realization of debt in IBBI if a company is under liquidation? First of all, these are the parts that he has to prove the security interest. He has to file the claim in the liquidation. Company is going on the claim. He has to submit a proof of the security interest. But in IBC also, he cannot directly take over and sell it. He has a duty first. He will first inform the liquidator that I am getting this price for selling this asset. After giving this information, now liquidator has a 21 days time period. In this 21 days time period, he can inform within 21 days of the receipt of information. He says he got some person who is willing to buy that secured asset at a price higher than this price. He says, I am ready to buy in the 30 days. Then he will intimate it to the secured creditor. If such person is available who is ready to buy the secured assets before the expiry of 30 days at the price which is available to the secured creditor, then secured creditor has to sell to the buyer, which is find out by the liquidator. But if liquidator is not able to find out, then secured creditor can sell it to the person to who he has identified as a buyer. What it is saying, this provision of this regulation shall not apply if he has enforced the security interest under the SARFAESI or RDB Act. If he has taken over the possession of the secured asset under SARFAESI, sell it or transferred it to ARC, then no need of intimating it to the liquidator, no need of intimating to the liquidator about the price, or liquidator is under no obligation to find out the buyer. Then it will go under the SARFAESI as it is going. But Whatever he realized, he has to pay a proportionate amount due for the IRP cost and to the workman dues. That is required here itself. He cannot keep all the realized amount himself. He has to give a proportionate share in the IRP cost as well as in the workman dues. So this was basically IBC and the SARFAESI brief. Now, how they are interacting with this. Let's go ahead with some of the important judgments. First of all, the purpose of IBC and SARFAESI is altogether different. Purpose of IBC is to reorganize and run it as a going concern. But the SARFAESI is a recovery mechanism which is available only with respect to NPAs for the financial institutions and the secured creditors. This we have discussed. Now, there is a non-obstant clause in IBC, which is saying IBC is the supreme section 238 is saying, just like there are wordings in section 35 of the SARFAESI, similar are the wordings in the IBC itself, that the provision of the code shall in effect notwithstanding anything inconsistent there contained in any other law or even in any instrument. This non-obstant clause establishing the primacy was first recognized in Unigreen Global Private Limited by the NECLAT, holding that IBC is superior to the SARFAESI Act. And even you must have seen, like you have mentioned, PMLA, it was been said that the law which has come later, at the time of enacting that legislation, the lawmakers were aware of the provisions available in the existing laws. So if they have inserted this overriding clause in it, it means this clause will override over the all previous existing laws, even though they are having a non-obstant clause. The court held in this case that as soon as the moratorium was imposed under the IBC, the proceedings under section 13(4) of the SARFAESI Act, like taking over the possession of the assets or the management or appointing receivers, they will be ceased. Even in the case of Rakesh Kumar Gupta versus Mahesh Bansal, it was held that even a pending proceedings under the SARFAESI Act, means it was being clarified that if a proceeding is pending in SARFAESI, can creditor come and file an application under section 7 of IBC? Yes, he can come and file an application under section 7 of IBC, though proceedings are there in SARFAESI also. Then there is one of the important case, Encore ARC company. And Encore ARC means it is in SARFAESI and it has taken an action against the Charu Desai. NECLAT has held that whenever IBC and SARFAESI came into conflict, it's the IBC which will prevail. What has happened in this case? There was a company, Calix Pharmaceutical Limited, which has taken a loan from Dana Bank in lieu of its property as a security. Now the principal debtor defaulted in the making of the payment. And Dana Bank initiated a proceedings under SARFAESI Act to confiscate the property because in 2011, IBC was nowhere in pick. So they have initiated, and finally in 2017, bank took over the possession of the property. Though from here itself, we can see why IBC was needed, that a default that was there earlier, means he say in 2011, from the 2011 as loan is there and it is being defaulted, actually the takeover is, possession could be taken over in 2017. But in October 2017, SBI made an application under section 7 of IBC. Now, IRP is under a duty to take over the assets which are being owned by the corporate debtor. And the asset was still standing in the balance sheet of the corporate debtor. IRP said that as moratorium is there under section 14, these assets shall be handed over to the corporate debtor. Dana Bank approached NCLT and asked for an interim order to prevent IRP from demanding the property because it has already been confiscated in the SARFAESI. And now it is in the possession of the bank under the SARFAESI Act. Dana Bank argued, and it has referred a case that was being, judgment was delivered by the Supreme Court in Transport versus Union of India, in which it was being held that once a possession has been taken, all the rights relating to it will vest in the secured creditor. Now, when the NCLT analyzed this judgment, it was being held that In transport, Supreme Court has held that once the bank has taken the possession, then the right, title and interest can be dealt as if it is the owner. So what it is not stated that they are the owner of the asset. They as if word does not denote the actual ownership. This is the deemed ownership. And the asset is standing in the balance sheet of the corporate debtor. Under Section 18, IRP is under a duty to take over the control and custody of the assets over which the corporate debtor has ownership right. Now, what to do? Dena Bank given appeal in to the NECLAT. And then NECLAT said, as per Section 18, it is IRP who is under a duty to take over the assets under the ownership of the corporate debtor. Though the possession has been transferred, but Dena Bank has not become the owner. The ownership still lies with the corporate debtor. And also the title has not been transferred to any of the third party. So that's why it was being held that transport judgment was in 2008. IBC came into existence much after that. Therefore, the non-obstant clause of the court indisputably established that it will prevail over the SARFAESI Act in case of conflict. Very clearly stated by the NECLAT in this case. Now, the provision for the appeal are also there in the IBC, that from the order of NCLT, the grounds are also mentioned, that you can go to the NECLAT, and from the NECLAT you can go to the Supreme Court. And the grounds on which one can go ahead here is that are also being mentioned here. One thing that what is there is, if any action against personal guarantor is taken during the CIRP, if any action of under IBC is taken against a personal guarantor during the CIRP of the CD, the same shall be dealt by the NCL. And then anything which relates to the insolvency proceedings, it shall go to the NCLT. NCLT is the only authority with respect to any application or proceeding against the corporate person for the claims, for the question of priorities, whatever be the decision making with respect to the distribution of the assets, it will be with the NCLT. Then the appellate authority is there, and the points are being mentioned with respect to which appeal can be made. They are being mentioned in, say, the Section 61. We are not discussing right now the same, because whenever they will come in the judgments, we will refer these cases. One thing to underline here is, again, just like in SARFAESI, there, no civil court or authority has a jurisdiction to entertain any suit or proceeding for the matter in which NCLT or NECLAT has jurisdiction under the code. So we cannot go to any other authority, but still we are going. Cases are there and still they are being decided. And the timeline is being mentioned for this. Now, one of the question is, if in the SARFAESI, when is sale set to be concluded? Any idea? When we say that sale is concluded, ownership is transferred in SARFAESI. Sale of certificate is being issued whenever in SARFAESI, the property secured asset is being sold. Sale of certificate is issued. Is that sale of certificate a conclusive proof of transfer of ownership? Is it different from the concept there in the Transfer of Property Act? If sale certificate is issued only on receipt of part consideration upfront and remaining later on, and during that period the company is admitted to insolvency, then what will prevail? IBC or SARFAESI? Let's see what these questions are being answered in this Indian Overseas Bank versus RCM Infrastructure Limited case. I'm just opening some of the facts of the case first. When we talk about the Indian Overseas Bank, yes. If I go to the facts of the case, it says the bank had extended some of the credit facilities to the corporate debtor and the corporate debtor became irregular in payment. And on 13th June 2016, the loan account was classified as NPA. So the condition of NPA is satisfied. The bank took recourse to the SARFAESI, gave a notice under section 13(2). Demand notice was being issued. And this he has called both the corporate debtor and guarantor that you pay the outstanding amount. Since the corporate debtor failed to comply with the demand notice and repay the outstanding dues, appellant took symbolic possession of the two secured assets which are mortgaged exclusively with it. The same was done by the appellant bank in exercise of the power that is being given in the SARFAESI Act along with the Rule 8 of the SARFAESI rules. Now, the two secured assets whose symbolic possession was taken, one of the said property was in the name of the corporate debtor, other was in the name of corporate guarantor. An e-auction notice was being issued on 27th September 2018 by the appellant bank to recover the loan. So these are the facts. So on 27th September, 27th November, first e-auction failed. Then on 27th November, second e-auction notice was issued. On 12th December, second e-auction held. 3 persons became successful bidders by offering jointly a price of this for both the secured assets. On 13th December, sale was confirmed. The successful bidders deposited 25% as an earnest money. The appellant bank issued a sale certificate to them because they have to deposit the balance amount of 75% within 15 days, that is by 28th December 2018. Now, but they were not able to pay, so they asked for the extension which bank granted on 29th December that you pay by 8th March 2019. On 3rd January, NCLT admitted the petition which is filed by the ex-promoter, that is by the say corporate debtor. So the question is whether the corporate debtor are playing an escape out tool so that SARFAESI proceedings could not be enforced. These assets could not be sold. On 21st January, because the 75% amount was pending, the bank filed a claim in Form C. On 8th March, when it receives the amount from the remaining amount from the bidders, 11th March, he filed a revised claim. 15th July, when NCLT set aside the sale of the property owned by the CD, it cancelled that and neglect upheld the NCLT order. Now there is an appeal to the Supreme Court whether once a sale certificate has been issued under SARFAESI, can it be cancelled? Can it be set aside if before receiving the full amount? The same, if before receiving the full amount, the company is being admitted into the CIRP. So the appeal to the Supreme Court was there. So Supreme Court has given a very clear judgment in it. First, refer the section 14 that it has not stopped any action to foreclose or enforce, means you cannot even enforce the security interest. So once there is a moratorium, this cannot be, SARFAESI action cannot be there. The legislative intent is clear that the SARFAESI actions are all prohibited here. And section 238 was being mentioned. Various cases were being referred here. Now, one thing that was there is that if a sale certificate has been issued, it is a conclusive proof of transfer of ownership if we go by the provisions of Transfer of Property Act. This was one of the things that was being there, but then they say if even the whole of the price has not been received, but sale certificate has been issued, the title would pass on the transaction, and that depends upon the intention of the parties also. Various cases were being mentioned which are saying if the sale certificate is issued in an auction, it means the ownership has been transferred. But now there is a thin line difference that is being carved out, that this is a statutory sale in Transfer of Property Act, the sale is a voluntary sale. Second thing is, if we go by the SARFAESI rule 8 and 9, they say the sale would be complete only when the auction purchaser makes the entire payment. And then the authorized officer shall issue a sale of certificate in favor of the purchaser. This was the crux point where it was being held, that if the payment is pending, even though the sale certificate is being issued under SARFAESI, if corporate debtor is admitted in CIRP, that sales, the moratorium would be applicable to that sale, particular sale, and the property will vest back in the corporate debtor. This was the main thing that was being held by them. So it was held that according to the dates, they say that in the present case, the balance amount was accepted. The sale is a statutory sale, and it is falling much after the amount was received much after the CIRP initiation date in which the moratorium was there. And once a moratorium is there, it is going to override the provisions of the SARFAESI. And the important underlying point here is the difference that unless and until the entire payment is received in SARFAESI, the sale is not held to be conclusive, and the asset is deemed to belong to the corporate debtor. Is this case clear to all of you? Any query from this particular case? Anyone having any query for this particular case?
No, ma'am, don't have any query at all.
I just wish to know how many of you are there in the session itself. Please switch on your video. Please switch on your video.
Yes, ma'am.
Manishi, Mitali are here. I'm confirming from the others. Is there anything that is required to be clarified from this particular judgment?
No, ma'am.
Just adjusting sharing. Right. PPT visible to all of you?
Yeah, it's visible.
Now there is a next case,
Yes.
Krishnath Singh and another versus Vadyavati Cooperative Bank Limited. If we go through the facts, first of all, let's see what were the issues involved in it. They says that if the delay is beyond 3 years, can it be condoned? Obviously, any delay any delay as far as limitation period is there, it can be condoned under Section 5 of the Limitation Act. It is Section 5 of the Limitation Act which states that if there are sufficient grounds, then the delay can be condoned. Right? One thing there. Then there is two sections which were marked out here were Section 5 of the doctrine, this Limitation Act, and Section 14 of the Limitation Act, which says that whether it applies to the IBC and Section 14 of the Limitation Act basically deals with that if a particular suit is being filed in a wrong forum, then the time taken in that wrong forum has to be excluded from computing the limitation period. Though these two queries were dealing with the limitation period, but how they were concerned with the SARFAESI Act. Let's see this. Let's go for what were the facts, why they were so initiating this action. There was an appeal under Section 62 of IBC. Section 62 of IBC says anything which is related to the IBC provisions for the implementation or anything, there is any query, then appeal can be made to the NECLAT only. The financial creditor has filed an application under Section 7 for which the CIRP was initiated. So it was said that the corporate debtor has taken a loan of 1 crore rupees as a financial assistance. It was granted under an hypothecation agreement. But in from the May 12, is whenever it was taken a loan in 15th February, within 2-3 months, it has started making a default. Because it has started making a default by 31st March, it was declared as NPA. So SARFAESI is applicable because once it is a secured asset and it is declared, it issues a demand notice under Section 13(2) requiring to make the payment, failing which the secured asset will be taken over. The corporate debtor made a representation and that representation was being denied by the financial creditor requiring to make the payment within 15 days. They require him that you make the payment in the next 15 days. 13th December, financial creditor again issued a notice to the corporate debtor under Section 13(4)(a) so as to hand over the peaceful possession of the secured immovable assets. On 19th December, corporate debtor filed a writ application under Article 226 saying that he has challenged the notice of taking over the possession of the financial creditor. The writ petition was pending in the High Court. In the meantime, the authorized officer of the corporate debtor took over the assets and then he issued simultaneously, he took over the asset. District magistrate ordered for the possession by the financial creditor. He you take over the possession of the secured. That was being permitted by the district magistrate. But in the meantime, High Court stayed the order. He says, this possession shall be stayed. You cannot invoke the provision of SARFAESI Act. The writ petition was pending. That was not a final decision. That was an interim order in which the action under SARFAESI was stayed. Financial creditor went to the NCLT bench for initiating CIRP under Section 7. Notice of the petition was served on the corporate debtor. Corporate debtor opposed the petition saying that SARFAESI proceedings are under writ petition. They are being challenged and the proceedings are still pending in the High Court. So it was on a ground that yes. Then the NCLT admitted the application filed by the financial creditor and declared a moratorium. It states that corporate debtor has not opposed and given any plea of the limitations there. Because when we look for the requirement of Section 7, NCLT look for only whether there is a default or not, if the application is complete. And the third thing is the IRP which is being recommended, there is no disciplinary proceedings pending against him. Once these three conditions are satisfied, NCLT admitted the applications. Then the corporate debtor filed an appeal before the NECLAT under Section 61, saying that this financial creditor application should not be admitted because it is barred by limitation. Though this limitation criteria, this objection of limitation was not taken before NCLT, but it was taken before the NECLAT. Now NECLAT said that corporate debtor account was NPA, whereas the application under Section 7 was filed almost 5 years. That was stated in appeal before the NECLAT because when there is no limitation period prescribed in the Limitation Act, we go by that it has 3-year time period to take the action. That has elapsed, so it should not have been entertained in this. But when NECLAT dismissed the appeal with the observation that it was first time taken in the appeal and there is no observation of the adjudicating authority with respect to same. And then he said, now the thing is whether the action initiated in SARFAESI can be counted as the action taken to recover the loan and it can be excluded from computing the limitation period of 3 years. Yes. NECLAT examined and held that within respondent had filed within the limitation period, it has taken an action under SARFAESI. So whatever be the time period taken in taking action under SARFAESI till the time stay order is being given in the High Court. If we are going to exclude the time taken in the proceedings in SARFAESI till the High Court order, then it comes in the 3-year period, and that's why it is well within the limitations. That was basically held. NECLAT upheld this issue that it is still within the limitation period. And in last, it has sum up section 14 of the Limitation Act excludes the time spent in proceedings in a wrong forum. So if you say that the SARFAESI was not a right forum to proceed with, a bank has no right to go ahead in the SARFAESI. Even section 14 permits that even if it was a wrong forum, then the time taken before the SARFAESI shall be excluded in computing the limitation period, and the financial creditor is well within 3-year time period to initiate the action. Right. Now the next case is if the properties are auctioned under SARFAESI before IBC, then the moratorium, though there is a moratorium, aren't liquidation assets for insolvency. Moratorium cannot be applied. So it says that if before IBC, the auction has been conducted, the property has been transferred, consideration has been received in full, then moratorium is not applicable with respect to those particular debtors. Now, once that case we have decided, another case is whether imposition of moratorium is a bar to recover the amount proceeding against the guarantor under SARFAESI Act. See, corporate debtor is means the protection under section 14 is for the corporate debtor. But if the financial creditor or the operational creditor wants, can they take the action against guarantor under SARFAESI, not under IBC, under SARFAESI to recover the proceedings? This was the case being decided in Jayaprakash case versus State Bank of India. In this case, of Jayaprakash versus this, Jayaprakash was the personal guarantor of the corporate debtor. They filed an appeal aggrieved by the order of the NCLT in which the interlocutory application for various relief was dismissed by the adjudicating authority. What were the cause of action here? Give me just 1 second, yes. Actually, here, appellant filed the interlocutory application to direct the respondent because the bank who has initiated the action to recover the property of the personal guarantor, and it has gone for the public auction of the same property. Guarantor said that the corporate debtor has been admitted to the liquidation, which has availed the corporate debtor, which has availed a loan facility to a tune of this from the bank, to which the appellant stood as a guarantor. Yes. Corporate debtor availed a loan facility, and the facts of the case are that corporate debtor availed a loan facility from the bank to which the appellant stood as a guarantor. Jayaprakash was the guarantor there, and appellant property was a collateral security. When the corporate debtor makes a default and classified as a NPA, an application was filed under section 7 of the IBC to initiate CIRP against the corporate debtor, which was finally admitted. During the CIRP process, respondent number 1 submitted the claim. The corporate debtor submitted the claim, most of which were admitted, but CIRP failed. When the CIRP failed in liquidation, the corporate debtor filed the claim, which were majorly admitted. But bank filed an application under section 14 of the SARFAESI to take over the assets belonging to the corporate debtor and guarantor without disclosing the fact that the corporate debtor has been admitted to liquidation. The Metropolitan Magistrate permitted it. The action under the SARFAESI, and then appellant filed an appeal against the respondent number 1 under section 17 of SARFAESI that the possession shall be cancelled. During the pendency of the appeal, bank went ahead and issued a notice for the public auction. And then the public auction was being conducted there. Then the Jayaprakash filed an application. He stated that it is against that because the corporate debtor is under the liquidation and undergoing the moratorium. So no action can be initiated against the personal guarantor. In terms of section 62 of IBC, if the liquidation proceeding is pending, an application relating to the liquidation or bankruptcy of a personal guarantor shall be filed before the tribunal itself. So, bank shall not approach the SARFAESI for taking over the assets of the personal guarantor. He shall approach the NCLT for the same. In view of section 60, subsection 5C, tribunal only has a jurisdiction to dispose of the questions which are relating to the liquidation proceedings of the corporate debtor, and section 238 has an overriding effect. They were basically the things that were being mentioned, but tribunal dismissed the application. It said that this application is neither maintainable nor sustainable because personal guarantor is a stranger to the IBC proceedings. It is only between the bank and the corporate debtor which are party to the IBC proceedings. Personal guarantor cannot take shelter under it. If one wants to approach to NCLT, the notification states that with respect to personal guarantor, you can approach NCLT only if you want to initiate insolvency proceedings. It is not for recovery. If any action has been taken under SARFAESI to take over the asset, then NCLT has no jurisdiction to decide upon those cases. It can decide only with respect to the insolvency proceedings of the personal guarantor. So they were all being rejected. Similar concepts in these types. So in view of the complexity of the question raised, it was summed up that petitioner or appellant is not entitled to claim the relief because only to initiate insolvency proceeding, you can approach NCLT for personal guarantor. Apart from that, personal guarantor cannot take any shelter under section 65 because he is a stranger to the insolvency proceeding. Simultaneously, imposition of moratorium is not a bar to recover the amount proceeding against the guarantor under SARFAESI Act because the agreement of guarantee is an independent contract. Can a financial creditor file application under section 7 of IBC while proceedings under SARFAESI are going parallelly? Yes, he can very well file the same. This was being held in the Ravindranath case. We can say it is always open to a financial creditor to take all the possible steps to recover the money. So, though the IBC is having an overriding effect over the SARFAESI under section 238, but still parallelly he can go ahead for the same. Moratorium is to protect the assets of the company. Once the adjudicating authority is satisfied, what were the requisites for the admission of the application? Though the proceedings are pending in the SARFAESI, but if section 7 requirements are being complied with by a financial creditor, there is a default, application is complete and no disciplinary proceedings are pending against the proposed resolution professional. Adjudicating authority shall admit the application. It is not required to look into the other criteria. So it is being clearly stated that if these three conditions are satisfied, adjudicating authority need not go to the merit of the case. It is not deciding a money claim or suit. It is just admitting it. So if the three conditions are satisfied, it has to admit the application. This is regarding the interplay of IBC with the SARFAESI. That is being covered up here. Our next part 2 is with the interplay of IBC with the arbitration. Before starting with the same, I would like to have a break of 15 minutes so that we can start afresh with the next topic, right? So we are going, can we reassemble by 3:50?
Okay, madam.
Okay.
Yeah, it's okay, ma'am.
Okay. Shall we start?
Yes, ma'am.
Okay, just confirm whether the participants have come back.
Participants, shall we start now?
Yes, ma'am.
Yes, we can start.
Okay, fine.
Ma'am, I have one question. Should
Yes.
I ask it now or after the session?
It's related to SARFAESI.
No, this is related to actually conducting auction of a property owned by one of the suspended board members. Personal property, auction of personal property. So
Auction of personal property under which particular provisions?
No, see, the background is like this. CIRP of a company started, and the financial creditor, one of the financial creditor, conducted an auction of a personal property of a director, which is not part of CIRP process. It is completely a different asset, personal asset of the director. Auction was
Personal
conducted.
asset of the director was given as a security. Was he a guarantor to the particular loan that was being given by him to the?
Yes, yes, yes.
Then yes, against the guarantor, a financial creditor can initiate action even during CIRP.
Even during CIRP. Now, subsequently, when the auction was conducted, on that day, the director produced a document saying that 3 months back, some other financial creditor had started personal insolvency. So provisions of 95 got invoked, and there was a moratorium starting from the period 3 months earlier. So you cannot conduct auction now. But this fact was never brought on record by him till the auction.
Till the auction. See, this is what the conflict starts. If it was there, it should have been brought before the NCLT, basically. So this is altogether the practical issues. Though the guarantor can invoke, under which provisions he has enforced the security interest under SARFAESI.
Yes, ma'am.
So then again, there is a conflict between IBC and SARFAESI. And since to the extent I believe it is a default of the director that he couldn't bring it to the notice because he was getting a demand notice under section 13.2 of the SARFAESI.
Yeah.
He must have got the notice before the whenever the possession was taken over, he must have in record hands that this proceeding is going against me.
Okay.
So it's basically the default of the director, and it's really a great confusion. But still, insolvency proceedings, we came to a different conclusions in IBC where it is always stated that IBC will prevail over this.
Okay.
So we cannot give a conclusive judgment in it. On the face, whatever you are stating, it states that yes, SARFAESI will go ahead and they will go ahead with the auction.
Okay.
But because the sale is not concluded, the ownership is not transferred,
Okay.
then IBC can come into it.
Okay, ma'am. Okay.
Okay.
Thank you.
Yeah, welcome. Now, till now, one part we discussed about where the financial creditor can take action under SARFAESI or it is under IBC. What about the operational creditors? SARFAESI, no protection under the operational creditors, but the provisions in IBC with respect to the financial creditor and with respect to the operational creditors are different. How they are different? Let's go ahead with the same. When I went ahead with the provisions, we used to go in section 7, financial creditor straightforward file the application on default. But the procedure for the operational creditors is different. First of all, he has to serve a demand notice under section 8. And if that doesn't succeed, then comes under section 9 for initiating CIRP. So if first of all, there is a default of 1 crore or more, then the demand notice being served, then under section 9, CIRP application is being initiated, and then adjudicating authority admits or rejects the same. The rationale for a different procedure is that operational debt generally are of smaller amount, or they are recurring in nature. Second thing is, with respect to operational debt, possibility of dispute is high because they are related to goods or services. So there may be disputes with regard to the rendering of the quality of the goods or the services. Some terms are there. And that's why when these contracts are entered, they have arbitration clause for settlement of the disputes. Right? When we look for the section 8 of the serving of the demand notice, he will serve a demand notice to the corporate debtor demanding the payment. Notice served demanding the payment of the operational debt with respect to which the default has occurred. Right? Now, when the demand is there, the corporate debtor is under an obligation to revert a reply in 10 days of the receipt of the demand notice. And what he is going to bring to the notice of the OC is existence of a dispute. He can state that because there is a dispute on record of the pendency, or if any, or record of the pendency, that he can say, though dispute is there, it may not have been, no legal action has been taken, or it can brought to the record that a suit is pending or arbitration proceedings is going on before receipt of the notice, demand notice. So what is required here is that it shall be a pre-existing dispute which was existing before receipt of demand notice. Or he can give the proof that yes, I have made the payment of unpaid operational debts by way of some electronic transfer or whatever with the check being given, that could be there attached with it. Now, after the demand notice phase, then CIRP may be initiated because there is no dispute pending with respect to the debt, with this operational debt, or the corporate debtor has not submitted any proof of payment of unpaid operational debt. In those cases, application to initiate CIRP by the operational creditor can be made if after expiry he does not receive a payment or a proof or notice of the dispute with respect to the debt. Along with him, he shall give an affidavit that there is no notice given by the corporate debtor relating to the dispute of the unpaid operational debt. This is what is necessary to be submitted with the Section 9 application. They are the other. Now, under subsection 5 of Section 9, adjudicating, the underlying word here is shall. The adjudicating authority within 14 days shall admit the application and communicate the decision if, I am just going by this, no notice of dispute is received by the operational creditor, or there is no record of dispute in the information. But he shall reject the application and communicate to the operational creditor and corporate debtor if notice of dispute received by the operational creditor, or in the record of the information utility, there is a notice of dispute. Obviously, if there is such notice, then Section 9 application cannot be admitted. This is where the arbitration comes into play now. What are the provisions of the arbitration? In the brief, we are going to look for the provision of the arbitration. When I look for the provision, arbitration is basically out of court settlement. To consolidate the laws which are relating to the domestic arbitration or international commercial arbitration or foreign arbitral award or conciliation. These are basically, whenever the parties belong to India, we call it as a domestic arbitration. Otherwise, if one of the parties outside India, we call it as an international commercial arbitration. I'm not going in all these, what are the arbitration and all. I hope you all know about it. These things, because I want to discuss with the judgments basically which have come with respect to this. Later on, we can go ahead what it is. One thing to be counted here is the definition of the arbitration agreement. Because sometimes it is disputed that there is no arbitration at all. So Arbitration Act says that arbitration agreement means there is an agreement by the parties to submit to the arbitration all or certain disputes which have arisen present, means which have right now they are, or they may arise in future in between. So it is not with respect to any of the past disputes they can talk about. It is present or that may arise between them with respect to a defined legal relationship. And that needs not necessarily to be a contractual. Section 9 covers the contractual. Operational debt is always contractual, which is covered in IBC. But arbitration can be with respect to even something which is beyond the contractual relationship. Now, if I look for the definition in the Contract Act, it's contract for a contract agreement need not be in writing. But when there is a specific act requiring, then it should fulfill the requirement of the act. So arbitration agreement says that it shall be in writing. And what could be the mode of writing? It can be a separate agreement. In a contract, it can be a clause, or it can be given by email, letters, telegrams, other means, which is stating, yes, there is some record of agreement. Or sometimes what happens, whenever such arbitration proceedings are initiated, statement of claim and defense are being filed by both the parties. One of the party has stated that agreement is in existence and other party has not denied it. Even that is considered as that the arbitration agreement is in right. First of all, whenever there is a dispute, then the matter shall be referred to the arbitration. But if the same is referred to the court, then in the first statement of defense, they should be raised that matter is subject to the arbitration. Then jurisdiction of the court will refer the matter for the arbitration unless and until there is a belief that yes, there is no such agreement in existence. When the arbitration proceedings are going on, some of the interim relief may be required. These interim relief may be given by the court or it may be given by the arbitral panel. That is, though it may be given by arbitral panel means a arbitrator which are appointed to give a adjudicate upon the particular dispute. Court can give this relief even before or during the arbitral proceedings or even before the arbitration agreement award is being enforced. What could of the measures could be there? Guardian may be appointed for an unsound person or a minor person, and interim relief may be required for preservation, interim custody or sale of the goods which are subject matter of the arbitration agreement. This is where the conflict is there. If custody is required of a particular goods or sale is required and application is admitted in the CIRP, then IRP will require the custody of the goods which belong to the CD. Then what happens whether the arbitration will have a conflict with the IBC? Amount in the dispute may be required to be secured. Property may be required to be detained or some other actions may be required. So whenever a court is giving a relief, within 90 days, the proceedings shall initiate. The arbitrator shall always be even. Interim measures may be given by the tribunal also. Once the tribunal is constituted, tribunal means the arbitrators are being appointed by the parties. After that, they may decide and give those interim reliefs which we were talking about to be provided by the court. And once the arbitral tribunal is in existence, court doesn't interfere basically. That is the arbitration rule. And in the arbitration, the parties have their own rules. And CPC and Indian evidence are not there. They are free to determine anything. What is in existence, they say. Now, first of all, there is arbitration a time-bound proceeding just like in IBC? Yes. As far as the Act states, it is time-bound because it states that statement of claim and defense shall be completed within a period of 6 months from the date of appointment of the arbitrator in writing. So first of all, the parties will submit their defense and claim within a period of 6 months. Then thereafter, within 12 months, award is required to be given. With the consent of the parties, further extension of 6 months may be given. But if beyond that extension is required, court permission is there and required. And if the court doesn't give permission, arbitral proceedings shall terminate. So one of the question is, again, the arbitration proceedings are also time bound. One thing that is there required is this. There the conflict arise. Section 34. It says that can arbitral award be challenged? One thing, if the arbitral award is given after the mutual consent of both the parties, then it cannot be challenged. Then how can it be challenged? What is the procedure? If a request from the date on which the party had made an application, party making the application had received the arbitral award, or a request or some corrections was required after the correction, within 3 months an application is made and the award is being challenged in the court after serving the prior notice. After serving the prior notice within 3 months of receipt of the award, and the court is being approached for challenging the award, the court shall dispose of the same within a period of 1 year from the date on which the notice is served upon the party. So again, a period of 1 year is being mentioned under section 34. Then on what ground court may set aside the award? The party making the application has to say that it was under some incapacity, or the agreement is not valid, or the proper notice of appointment arbitrator is not properly appointed, or it deals with the dispute which is not falling in the arbitration. Arbitral tribunal is not properly constituted. Some of the provisions are there in which it may set aside. But if the award is in conflicting the fundamental policy, it is against the moral or justice, or it is induced by the fraud or corruption, then it shall be set aside by the court itself. If the court finds that award is vitiated by the patient illegality appearing on the face of the award, then it may be set aside by the court. Finality of the awards, if the award is not challenged, or if challenged but it's rejected by the court, then we say it is final and binding upon the person claiming under them. How it is to be enforced? It is to be enforced within 3 months of the final decision with respect to the award, as may be, and can be enforced as CPC, it may be there in the CPC. The order of the court against which appeal is held. Let's go ahead with, first of all, some of the judgments before going in the arbitration first. Let's go for some of the judgments which are relevant in the time period. First of all is the judgment of K. Kishan versus Messrs. Vijay Nirman Company Limited. It's one of the finest judgment which has gone in depth with respect to the arbitration and IBC. The present appeal, the question was that can IBC be invoked for an operational debt where an arbitral award has been passed against the operational debtor, but still not finally adjudicated upon? When the final adjudication will be there, if within 3 months it has been challenged and the court has not decided upon that, or 3 months time period has elapsed, then it will be considered as final. But unless and until 3 months are being passed or it has been challenged, we cannot say it is a final one. The facts are the company was into a subcontract agreement. There was an agreement between the company which is known as KCPL company. KCPL company has entered into an agreement with some SDM Projects Private Limited, and Vijay Nirman has entered into as a subcontractor with the KCPL company. There was a memorandum of understanding agreed between them that the disputes and differences will be referred to the arbitral tribunal. Disputes referred were delivered an award on 21st January 2017, in which there were 3 claims. One of the claim was admitted. Yes, it was due. But then the 2 other claims were, which arise out of interest. Another claim was also allowed to a higher rate of payment, but 3 cross claims were rejected. 2 claims were permitted, but then whatever the cross claims given by the respondent for his payment, they were being rejected. Then a notice was given by the respondent to KCPL and under section 8 of the code, and within 10 days, KCPL disputed the invoice, saying that this amount is subject to the arbitration proceedings. So you are liable to pay a larger amount to them, because that was a case of a cross claim. KCPL has to make some payment to the respondent. Respondent has to make some payment to the KCPL. Now KCPL said, whatever you are demanding, you have to pay more than that to me. And this is under the subjudice of the arbitration proceedings. After the notice and reply on this, a section 34 petition was filed by the KCPL, challenging the award also. This petition was filed within the limitation period, and a petition under section 9 of the code was also filed. It said that the amount was included and this is an operational debt, and operational debt being there, there is nothing that is being submitted regarding the payment. So the same shall be challenged. NCLT gave us judgment saying that the award that was challenged in 34 states that the first respondent was fair enough to admit that yes, the claimant is entitled to one particular sum. But a section 34 petition was pending was irrelevant for the reasons that the claim stood admitted and there was no stay of the award. NCLT stated because in 3 claims, one of the claim has already been admitted and that was not disputed. That has nothing to do with section 34 challenge of the award. That's why section 9 petition was admitted. Then an appeal was made and the appellate tribunal again held that section 238 will prevail over the Arbitration Act. Because they said nothing, but then Mobilox Innovation Private Limited case was being highlighted in this particular case, which was not being considered neither by the NCLT nor by the NECLAT. That was basically the thing in it. They said this is not a disputed debt, basically. I just want to say this. Let's go through. Then what was being held by the Supreme Court is that if you go through the section 9, subsection 5, 2D of the code, an application under section 8 must be rejected if a notice of dispute is received by the operational creditor. And they say in the present case, if you go for the section 8 notice, is the fact an arbitral award was passed on 21st July 2017. And it was the case that was filed. The fact that the reply to the notice was within 10 days and the dispute was pre-existing, this cannot be doubted. But learned counsel strongly relied that this is an ordinary case because one of the 1.71 crore payment was admitted in the arbitral proceedings. Remaining 2 claims were under challenge, but one claim was settled that this was due. And the 2 counter claims were being rejected because they were saying they were more than the claims beyond. That's why they were subject to the challenge. So they say, okay, they went ahead. This is difficult to say that proceedings, but we cannot say that there was a claim also with respect to some other amount that was being challenged on the ground of price adjustment. So we cannot say, because this is an entire contract. It is not that this claim has been settled, 2 other claims had not been settled. This is an entire contract and dispute is still pending with respect to the entire contract. They refer to the Mobilox Innovation case. They said that the court this court refer to the legislative guide on the insolvency law of ancestral law. One of the thing is whether debt is subject to a legitimate dispute or set off in an amount equal to or greater than the amount of the debt. Because what will be the dispute? They say either no debt is pending, or they say whatever debt is pending, it is more, you are claiming more than what is due. Or they may say we also have a right of payment from you. We also have a debt, so you have to pay us because our counterclaim is more than what you are claiming from us. Another thing, what ancestral law is said that insolvency process should not be improperly used. If a creditor is using the insolvency as a substitute for debt enforcement procedures, then that is not recommended. In Mobilox innovation case, they say the original bill has a word bona fide dispute in the definition. But this word bona fide was dropped. What is an impression behind it? That if the bona fide is dropped, so when the adjudicating authority is considering the application, if a dispute is pending, then it will not entertain the application under section 9. When they refer to, in Mobilox case, when they refer to section 8, judgment said that what is important is existence of the dispute, suit or arbitration proceeding, and which must be pre-existing. That is, existing before the receipt of the demand notice or invoice as the case may be. So adjudicating authority, what it has to determine? Operational debt is there, exceeding 1 lakh. Documentary evidence that this is due and payable and not paid. It means default is there. Existence of debt between the parties or the record of pendency of suit or proceeding. If there is any dispute or there is a pendency of a suit or arbitration proceedings filed before the receipt of demand notice. If these 3 conditions are satisfied, it shall admit it. If any is lacking, it shall reject the same. Apart from the above, the adjudicating authority must follow the mandate given in section 9 and in particular section 9 subsection 5 and admit or reject the application. One of the things that was being considered in Mobilox was that objects of the code for operational debt is to ensure that because the code, it has been visualized that the code has different approach for the financial debt as versus service your operational debt. So object of the code is to ensure that the amount of operational debts is usually smaller than that of the financial debt. It does not enable financial creditors to put the corporate debtor into the CIRP prematurely or initiate the process for some extraneous consideration. That's why it is enough if a dispute exists between the parties, it shall not be admitted for CIRP. That's why how it was being summed up. Once the operational creditor has filed an application which is otherwise complete, adjudicating authority must reject the application if notice of dispute has been received or there is a record of information utility. Such notice must bring to the notice of the operational creditor, yes, there is a dispute existing or there is a suit or arbitration proceedings listing relating to a dispute is pending. All that is to see at this stage, yes, after an investigation, dispute is not a fake one. Then it shall admit the same. Then following this judgment, it was being held that the creditors cannot use the operational creditors cannot use prematurely because in the operational debt, 1 lakh at that time was a very small amount. And generally it was thought that it can be used just to trouble the corporate debtor, to put it into the CIRP for a very small amount. That's why it was held that if there is a pre-existing dispute, no, it will not be admitted into CIRP. It was being held that operational debt, whether the debt can be said to be disputed, we have no doubt that filing of section 34 petition against an arbitral award shows, yes, there is a pre-existing dispute till the final adjudication under section 37 took place. So till it is not finally decided under section 34 and even the court gives order, it can further be challenged under section 37. Unless and until section 37 it is finally decided, it cannot be entertained in the IBC. So this is what a relief they are giving with respect to the operational debts. If section 34 petition challenging the arbitral award be clearly and unequally be barred by the limitation, yes, because you have what challenge can be taken in the operational debt? They say that the arbitration proceedings are barred by the limitations because arbitral award can be challenged within 3 months with an extension of 30 days if obtained. That could be a ground for the challenge. But if it is not challenged, then arbitral proceedings are considered as a dispute under it. Now, then what are the various scenarios apart for it? There is one thing, the moratorium is construed very differently. Delhi High Court in Power Grid Corporation of India, there was a petition under Section 34 of the Arbitration and Conciliation Act for setting aside the arbitral award passed by the arbitral tribunal in favor of the respondent. The award is basically in the nature of pure money decree in favor of the respondent. During the pendency of these proceedings under Section 34 of the Act, an application under Section 7 of the IBC was filed by a financial creditor against the respondent company, seeking initiation of the CIRP against the respondent, and the NCLT admitted the same. Now see, in the arbitration, basically operational debts, creditors goes. But in the meantime, if financial creditor goes in the IBC and the petition application is admitted, then the moratorium comes into effect. The question now is, if the present proceedings under Section 34 need to be stayed, because now there are different parties involved. One who has undergone the arbitration and the proceedings under Section 34 is going on. The other financial creditor goes to the IBC and Section 7 application is admitted. And what will happen to those proceedings which are undergoing Section 34? Can you tell me what will happen to those proceedings? Because they are in that operational creditors is involved, while NCLT has initiated this application under Section 7. The respondent case is that if the proceedings are stayed, respondent would be unable to execute the award given in its favor for an extended period till the moratorium exists. Right? Hence, the issues is if the word proceedings, they are saying, whether the word proceedings in Section 14(1)(a) includes all legal proceedings, or it be read restrictively to mean a particular type of legal proceedings. That is what it is saying, because in this now the moratorium is there. Corporate debtor is saying, if you are prohibiting Section 34 proceedings, then I may not get what I may be entitled under Section 34. You have admitted the application, but I will be deprived of Section 34 benefits. Now, this is what I consider in the beginning, that Section 14 is dealing with prohibition of the proceedings against the corporate debt. So the same thing here, corporate debtor saying Section 34 is going to give me a monetary benefit. Then why to stop those proceedings by imposing the moratorium? Proceedings does not mean all the proceedings. It applies only to the proceedings which are against the corporate debtor. It was being stated even in the Canara Bank that moratorium is not going to apply to proceeding under Article 32 or 226 of the Constitution of India. Object of the code is to provide relief to the corporate debtor through standstill period during which its assets are protected from diminution or dissipation. That's why, as a corollary, we have to strengthen the financial position of the corporate debtor and not to put in some burden, so that because we want to run it as a going concern. So our interpretation is very clear. It was being required by the respondent that this moratorium period of Section 14 is only for those legal proceedings which are against the corporate debtor. If it is for the benefit of the corporate debtor, then they will not be prohibited. Similarly, the Delhi High Court in SSMP Industries Limited versus Perkan Food Processors Limited was dealing with the issue whether a counterclaim against the corporate debtor is barred in the light of moratorium imposed under IBC. It was held that although a counterclaim is technically a proceeding against the corporate debtor, it has to be adjudicated by the arbitral tribunal, as the corporate debtor cannot claim the money unless and until counterclaim is adjudicated upon. So they are saying corporate debtor has its own claim and there is a counterclaim also, for which arbitral tribunal has to decide. Unless and until that counterclaim is decided, how will corporate debtor has its own claim? How will it claim its own money? So it was said that if it in this scenario, a moratorium is imposed, then corporate debtor claim cannot be adjudicated. That's why they say that following the power grid judgment, they did not cause prejudice to the assets of the corporate debtor, and this arbitral proceeding shall continue till the time this counterclaim is adjudicated. Then Supreme Court decided in P. Mohan Raj versus Shah brothers case that relying upon the power grid versus Jyoti structure case, in which the Delhi High Court held that Section 34 application to set aside the award would not be covered by Section 14 of the IBC. This judgment does not state the law correctly. What does it say? Supreme Court says, no, it does not hold the law correctly, because it is clear that Section 34 proceeding is certainly a proceeding against the corporate debtor, which may result in an arbitral award against the corporate debtor being upheld, as a result of which money would then be payable by the corporate debtor. A Section 34 proceeding is a proceeding against the corporate debtor in a court of law pertaining to challenge to an arbitral award, and it will be covered as an appellate proceeding in a decree of a suit. Therefore, it is whatever was aimed in the power grid corporations or in the further that they were saying no, Section 34 proceedings may go ahead. This was being stopped by the Supreme Court in P. Mohan Raj case. In Supreme Court took another view. Supreme Court said, okay, if the counterclaim is decided, then who has to pay the money? Corporate debtor has to pay the money. If the corporate debtor has to pay the money, then this is not permitted under Section 14 of the moratorium. If this is not permitted under Section 14 of the moratorium, so there is no way out. There is nothing to say that this arbitral proceeding under Section 34 are not covered by the Section 14 of the moratorium. So altogether, these judgments with respect to Section 34 was turned down by the Supreme Court in P. Mohan Raj case, basically. This was the P. Mohan Raj case that we discussed till now. This was the Mobilox Innovations case. Now, there are some of the provisions of arbitration that we just didn't cover because I was inclined to cover the judgments first with respect to this same thing. Now, let's understand what was there in the arbitration basically. First of all, we decided that the arbitral tribunal is being constituted. Pleadings are being there. That has to be decided within 12 months with 6 months extension. This we have covered. And this could be done in the fast track procedures also and settlement also. Let's go ahead with one thing I just want to cover from here also. Yes, Section 34 we have done on the ground for challenging the arbitral final is there. Right. Now, can the order of Section 34 be challenged? Yes. The order of the court against which appeal is allowed, if they are refusing to refer the parties to the arbitration, they can be challenged. If any measure is refused to be granted under Section 9 or 17, the order can be challenged. Or if they refuse to set aside under Section 34, the order can be challenged. So till the time the order is finally decided under Section 37, the proceedings under the arbitration, we say that they will continue ahead. The order of the tribunal against which the appeal is allowed, accept the plea or grant or refuse. If the order of the tribunal may also be subject to an appeal, if a plea is being raised that the arbitral tribunal does not have a jurisdiction or it has crossed the scope of its authority. then it can be challenged in the arbitral appellate tribunal, and unless and until it has been decided, there can be no question with respect to the operational debt being Section 9 petition being considered by the NCLT. I just want to say yes. Let this Vikram Sharma, yes, we will. I'm just looking for one of the judgments also. Anything else in the meantime, if you want to ask, you can ask. I'm just looking for some of the judgments also. Any other query if you want to ask? Otherwise, I would like to read once again the Mobilox judgment that we have run it little bit in haste so as to cover it. Only the Mobilox judgment. See, now if we go through the constructs in the with respect to the operational debt of the Mobilox innovation, it has considered that the court has basically the legislative guide is to spoke about whether debtor is a subject to a legitimate dispute or set off in an amount equal to or greater than the amount of the debt. And another thing they say that the machinery of IBC shall not be used as an inappropriate substitute for debt enforcement procedures. Second thing is that again I am repeating that they have dropped the word dispute that was originally bona fide in the definition of the dispute that was there in the original bill. After referring to the Section 8, the judgment went on to hold that what is important is the existence of the debt or a suit or arbitration proceedings which must be pre-existing before the receipt of the demand notice or invoice. Then this we have done this. They shall follow the mandate for non-operational this. This judgment they have held, it was held in Mobilox that the alarming result of the operational debt contained in an arbitral award for a very small amount of 2 lakh rupees cannot possibly jeopardize an otherwise solvent company which is worth several crore of rupees. Such a company would be well within its right to state that it is challenging the arbitral award passed against it. And mere factum of the challenge would be sufficient to state, yes, it is a disputed award. And yes, such a case would come within para 38 of Mobilox innovation being a case of a pre-existing ongoing dispute. The court cannot be proceeding in respect of those which are still pending. We repeat that object of the court is, at least as far as operational creditors are concerned, to put the insolvency process against a corporate debtor only in clear cases where a real dispute between the parties as to the debt owed does not exist. So what the Mobilox has clarified that with respect to operational debt, only those cases are intended to be admitted in the CIRP which are clear slate, in respect of which there is no dispute. And generally, these are concerned with I again repeated, with the goods and services. So whenever the contract entered, they may use to have the clause for the arbitration. So if the proceedings are pending in the arbitration, then they will not be entertained. If the proceedings are already pending in the arbitration, same operational creditor cannot come and raise the dispute. But like we read the case, some other financial creditor come, then there is no question of dispute at all. Then it will be admitted. Then what would be the fate of these proceedings? There were different things. They were being saying, no, let these proceedings be continued and whatever will the final, it cannot be imposed against the corporate debtor. But Supreme Court in P. Mohan Raj case finally settled the case that if CIR, if corporate debtor is admitted to CIRP, even the proceedings under Section 34 will come to a halt in the Arbitration Act itself. Then again, it was held in the Mobilox case that as an operational debt is concerned, all that is to be seen is that can be said to be disputed. And again, filing of Section 34 petition says that there is a pre-existing dispute. And this pre-existing dispute will be washed in the IBC only if the same operational creditor is invoking Section 8 and 9. Only then there will be a conflict in Section 34 and the IBC provisions of Section 8 and 9. Again, they clear. And if there is a limitation period, yes, it was permitted in Mobilox that limitation provisions on the basis of the Limitation Act, plea can be taken and Section 34 petitions can be challenged. And it can be said that there is no pre-existing dispute because whatever going under Section 34 in the arbitration proceedings, it is barred by the limitation. If that is the plea, that it is barred by the limitation or it is before the wrong forum, Section 14 cannot be, Section 14 of the Limitation Act, no extension, no condonation of delay under Section 5 can be there. And it is, limitation period is applicable with respect to that arbitral award. Only in that case, we say that there is no pre-existing dispute. Apart from that, so Mobilox has given two ways. It says that if you want to go ahead with Section 9 and 8 of the IBC, for those debts which are in disputes in the under Section 34 of the Arbitration Act, you can take a plea that that award is barred by the limitation, or you can take the plea that Section 14 of the Limitation Act is not applicable with respect to the arbitration. So this is basically the cases. We have gone through it. Anything else, if you want to know, you are most welcome in the IBC and anywhere else. Any other query with respect to your... Now, there is one thing I would like to discuss with respect to moratorium. Now, this, if we have read Section 14(1)(a), it is saying that the proceedings which are against the corporate debtor cannot go ahead. And Section 33 says in liquidation, proceedings by or against both cannot go ahead. And if liquidator takes the approval of the adjudicating authority, only then the proceedings are permitted. So Section 14 and 33 are giving two different ways. Section 14 of the code is prohibiting the institution or continuation of the suits or proceedings. Here, the moratorium aims to maintain the current state of affairs, aiding in the resolution process by consolidating the company's assets and preventing their dispute. 33(5) is saying subject to Section 52. And further, Section 35 is saying that it is the duty of the liquidator to institute or defend the suit, prosecution, or legal proceedings which are there in the name or on behalf of the corporate debtor. So there is a striking difference between the two. If we talk about the moratorium versus arbitration phase, there may be two cases. One case that there is a fresh arbitration proceeding during CIRP or liquidation. In Alchemist ARC case, the Supreme Court of India held that such arbitration which has been instituted after the moratorium is non-est. It is not permissible at all. Company facing CIRP to recover its debt, the company facing CIRP can initiate legal proceedings including arbitration. But in the liquidation phase, it has to take approval of the NCLT. In such arbitration with caution, one can say that counterclaim against a company are maintainable if they are essential to the recovery that the company seeks and are associated with the same transactions. So in this Alchemist ARC case, the Supreme Court has clarified that any arbitral proceedings which with the setting of the claim and counterclaim is ultimately going to add something to the pocket of the corporate, then they are permitted. If they are against the assets of the corporate, then they will not be permitted. Similar was the decision in Jharkhand Bijli Virtan Nigam Limited. In addition, the concept of set-off was also recognized, enabling the offsetting of claims. And this offsetting of the claim was also given in the IBBI liquidation process regulations, that if any party has a set-off for the claims, it can also be admitted. It will give the final claim. If we will go through the forms which are being filed during the liquidation, it specifically have a clause where it says the counter claims provision. So these judgments are enabling for setting of the counter claims during the CIRP if they go for the arbitral proceedings also. If the arbitration proceedings, what will happen to the fate of those arbitration proceedings which are initiated prior to CIRP or liquidation? Clearly, if we go through the language, it says they shall be stopped at the particular point. CIRP is prohibiting the continuation of arbitral proceedings against the company. Arbitration initiated by the company generally proceeds without interpretation, but if the company is a counter-claimant, then the arbitration continuity generally hinges on whether the proceedings aims to maximize the value of the company's assets or pursue a debt recovery action against the company. Underlying word here is against the same. If it is adding to the assets, it will go ahead. If it is a debt recovery action against the company, it will not go ahead. If we go through the Chennai Metro Rail Limited case, Madras High Court held that pursuant to section 33(5) of the IBC, no leave from the adjudicating authority is required to continue arbitral proceedings on the rationale that a power to grant leave also includes the power to reject the same. So if you are going to the adjudicating authority and asking for the permission, it may reject the same. If it rejects, a rejection of the leave means authority will take the case, will conduct the case, and in its wisdom, the legislation thought that in cases involving the inability to pay debts and where the resolution plan had failed, then what will you recover first? Means company wants to go, liquidator wants to go and recover the amount, but Madras High Court says, what's the use of this permission? You were not able to get any particular resolution plan. You don't have anything in pocket. You have come to IBC because you were unable to pay debts. So what will be there settled in your counter claims? So there is no use of any particular. That's why section 33(5) omitted to consider the case of pending matters. So those ongoing proceedings were stated that there is no need to take permission with respect to the ongoing proceeding. They are basically halted there, sir. Even the Kerala High Court in Orient Courier's case held that the upheld the order passed by the controlling authority under the Minimum Wage Act, even though the same was passed during the liquidation process. But then the view is different. Before liquidation, there is chance of resolution plan in which something could be received. But during liquidation, it is that nothing can be received there. There is one more observation of the Annapurna Infrastructure Private Limited, in which an ACLAT held that an arbitral award against the company would be treated as a default as stipulated under the code. So if there is an arbitral award and company is not able to repay under the same will be treated as default, and the company can go ahead on the operational creditor can go ahead on the basis of that to give as a proof. That could be given as a proof that yes, the company has made a default under section 9. So ultimately, last is award will be executed if it is in favor of the company, and if it will not be executed if it is against the company. So ultimately, if we go through the IBC provisions are basically for the benefit of the company. They are just a minute. I'm just stopping sharing right now. It's over. So as far as proceedings with respect to arbitration is concerned, they are saying if it is for the benefit of the company, it is fine. If it is not for the benefit of the company, they will not go ahead. And even the Madras High Court has questioned why to take permission of the adjudicating authority when you are in liquidation. What's the use of going on in legal proceedings? So anything else if you want to know, you are most welcome. This is what the subject I have covered in this particular session. Anybody else who wants to know anything? Anjali, are you here? I think there is no query at all. You can just confirm it.
Are there any questions? Anybody, do you want to ask any question?
No, madam.
No, not really. Thank you.
Oh,
So,
ma'am,
ma'am,
thank you so much.
ma'am, shall we conclude then?
Yeah, let's conclude it.
Thank you very much, ma'am, for such a knowledgeable and interactive. The session was very interactive. Ma'am, you are requested to share the PPT for the session.
Yeah, sure. Okay. Thank you.
I'm sending you mail to that.
Thank you.
Thank you. Thank you very much.
Thank you. Thank you, everyone.
So, Anjali, should we log out now? This is end of the day, is it?